Good morning, all. This return date hearing is in the matter of DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, KC, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Altamimi and Company. Lead counsel is Mr. David Holloway and Mr. David McCarthy. The first defendant is represented by Quinn Emmanuel Ucart and Sullivan. Lead counsel is Mr. Tom Montague Smith, KC, and Mr. George McPherson. Thank you.
Thank you very much. So the first item on the agenda for today is that I said that I would give my oral reasons for my decisions. First of all, to determine all outstanding applications today on the 12th of May, and secondly, for my decision under application number 11. So I'm going to give a brief oral judgment on both of those points. As to the former, on 29th April, the parties informed the registry of their mutual availability for an application hearing on Tuesday, 6th May 2025 to determine the three outstanding applications, namely applications numbers 8, 9 and 10, that's to say DMCC's application for security for costs, withdrawal of the attachments granted by the Dubai courts, and discharge of the injunction granted on 28th February as varied. On the same day, I indicated I would also hear application number 6, which is the claimant's disclosure application made on the 6th of May. On 30th April, DMCC indicated that it intended to have application number 10 heard on 12th May. I took the view that it may be more sensible to have all the applications heard together on 12th May, as at that time we had up to 3 days set aside. I was informed that the claimant's position was that all three applications should be adjourned to the return date hearing on the 12th of May, but that the defendant's position was that the claimant's application number 6 was not urgent and could also be adjourned to the 12th of May. The defendant's position in relation to applications number 8 and 9 were different. The defendant's position was that application number 8 was urgent and must be heard on 6th May for three reasons. One, substantial costs were being incurred and would continue to be incurred by the first defendant in respect of the return date here on 12th of May. The defendant's estimate of its costs and future costs up to and including the 12th of May hearing was $1,768,380.80. Secondly, no security had been offered by the claimant in respect of these costs, and this was said to be in circumstances where A, it was not in dispute that the claimant was out of the jurisdiction, and B, the claimant had produced no evidence despite repeated requests to demonstrate its ability to pay the first defendant's costs. Thirdly, if the application were not determined on 6th May and adjourned to be heard at the return date on the 12th of May, it would be rendered futile as set out in the first defendant's application notice. The first defendant said that it would thus be exposed to substantial and potentially irrecoverable costs, liability in respect of its own costs, including those but not limited to the cost of the return date hearing on the 12th of May. The claimant's position was that the application for security for costs had been made very late. It could and should have been made earlier. Any prejudice claimed in relation to the timing of its determination, which was denied, was of its own making. The application was said to be without merit. The claimant said that it had already provided $2 million in security to the court. The application concerned costs which had been incurred using the claimant's own proprietary assets and would be unjust for the claimant also to provide security for them. Further, it said both parties rely on the merits of the proceedings in respect to the application. The claimant's evidence for the second return date hearing, which would be filed the next day, would include evidence showing that the respondent had perpetrated a substantial fraud. Even if an order were to be made, which was denied, there was in any event insufficient time for the claimant to be able to make payment of security before the return date hearing. The claimant said it needed at least 7 days and up to 14 days from any order in order to arrange payment. As to the attachment withdrawal application, that's application number 9, the first defendant's position was that this application was urgent and must be heard on the 6th of May, because firstly, the precautionary attachments apply to the first defendant's bank accounts with the second through fourth defendants. The effect of these attachments was that the first defendant's existing bank accounts with the second and fourth defendants could not be operated in accordance with the ordinary course of business exception permitted by the order dated 28th May, as amended by the order dated 18th March. Secondly, despite steps taken by the claimant, the attachments were continuing to be implemented in a way which did not accord with the ordinary business exception in respect of the proprietary injunction. That continued to interfere with the day-to-day operation of the first defendant's business, including by adversely impacting the first defendant's ability, A, to pay invoices from the accounts, and B, to receive payments into those accounts. Thirdly, a further unexplained consequence of the attachment was that the bank accounts of a non-party to the proceedings had been affected and could not be operated in the ordinary course of business. It was not clear why this had happened, but there was no justification for it, and it had to be resolved without delay. Fourthly, the continuing impact of the attachments on bank accounts held by the first defendant and the non-party therefore required urgent resolution, which could not await the return date hearing on the 12th of May. For its part, the claimant said that the attachments made by the Dubai courts had already been varied to take into account the variation of the freezing order. The application seemed to have been conceived prior to the Dubai courts acceding to the claimant's request for the attachments to be varied and the respondent banks being notified accordingly. It was said that the first defendant persisted in the application after being provided with copies of the letters from the Dubai court notifying the respondent of the variations. Further, the first defendant's application provided no evidence of any actual loss being caused by the attachments. As set out in the evidence submitted by the claimant, it was said there was very little money left in the accounts which were the subject of the attachments, and the Aria entities, including Aria Dmcc and Aria Bio, had 55 bank accounts, including other accounts in and outside Dubai. It was therefore said there was no explanation as to why other accounts could not be used and receive payments. Indeed, the claimant said the defendant had previously notified the claimant's representatives that it was using one such other account for the payment of its legal expenses. The application, therefore, it was said, appeared to be being pursued tactically rather than because of any established evidence as to the application of the Dubai court's orders. As of Thursday, 1st of May, the situation was that the claimant was due to serve its evidence in reply in support of its continuation of the application on 2nd of May, and there was to be a full consideration of the merits and final determination of the injunction application on 12th to 14th May. As a matter of case management, procedural efficiency and procedural fairness, I was not persuaded that a delay of 3 working days between 6th and 12th May outweighed the significant advantage to be enjoyed by the court in considering applications 8 and 9 in the context of the entirety of the parties' evidence and the arguments at the hearing scheduled for 12th May. I therefore directed that all outstanding applications should therefore be heard together on the 12th of May. In the event things turned out differently, the next day the claimant served its evidence, which included a report from Kroll on the evidence in particular of the alleged fraud and a legal memorandum from Ogier Cayman. These were very substantial documents. The former ran to 485 pages with exhibits and the latter to 249 pages. This prompted Dmcc to pursue application number 11 seeking permission to serve evidence in reply and consequential directions, including the adjournment of the cross-applications for continuation or discharge of the 28th February injunction as varied. I substantially allowed the application largely for the reasons appearing in the third witness statement of Ms. Ovenden. Namely, first, Dmcc submitted that the evidence involved matters which required expert opinions covering at least 4 different disciplines. namely 1, forensic accountancy, 2, market practice in relation to Cayman funds, including financing practice, investment practices, and securitization, 3, the features and/or complexity of structured products, 4, the law governing the regulation of Cayman funds. I agreed, but did not, however, consider that a separate expert dealing with market practice was necessary, especially since the claimant had not relied on such an expert. Secondly, the Kroll report made serious allegations, and the claimant had said that a further report from Kroll was to be served. Thirdly, it would be procedurally unfair to the claimant to be entitled to rely, sorry, it would be procedurally unfair for the claimant to be entitled to rely on the 12th, at the 12th May hearing on the Kroll report, the supplemental Kroll report if served, and the Ogier memorandum as uncontradicted evidence. Fourthly, DMCC was entitled to a reasonable period of time within which to prepare responsive evidence to the Kroll reports and the Ogier memorandum. Fifthly, the 12th May could and should remain effective in order to determine the other applications. I therefore allowed DMCC's application. So those are briefly my oral reasons for the making of those two directions. As to today, then, we have the three applications, applications 6, 8, and 9. And what I propose to do is to take them in the order that they were filed, so 6, 8, and 9. We'll deal with each one, as I have indicated, within an hour and a half and take a short break between the first and second and the second and third. So with that introduction, then I think it falls to Mr. Holloway to open application number 6 for 35 minutes. Then Mr. Montague-Smith has 45 to reply, and Mr. Holloway has 10 for his response.
Thank you very much, Your Honour. So I will, as Your Honour will see, this application has three components to it. There's the you'll find it at page 5277. First, we're looking for bank statements, all the bank statements for the second, third, and fourth respondents. Second, we're looking for the correspondence and documents relating to the securitization procedure, which we've discussed at length before. And thirdly, a limited number of documents where we would like the originals rather than scanned or other copies. So before I take each one of those categories in turn, just a couple of introductory points on the application as a whole. The first one, and sorry, just bear with me, I've got to collect my note. So the first point is that we've been asking for this information for months, Your Honour, and we made the point strongly at the first return date that what Mr. Britton had produced at that point was not in compliance with the provisions of the order, the disclosure provisions. It didn't give a full account of onward dealings of the monies, it didn't give a full account of assets, and it didn't provide information that linked where the monies came in and where they went to. I made that point at various points of the return date hearing. We just received Mr. Britton's evidence at that point. But we then followed up with a letter on the 28th of March, which is at page 5298. And that I'll come back to that letter at various points today. But one of the paragraphs, for example, paragraph 3, we requested the bank statements at that point, the 28th of March. We were looking for all the bank statements passing between the first respondent and the other banks. The next sort of we've been saying right from the get-go that what has happened is non-compliance with the information provisions of the order. And I'll turn back to the order just to sort of frame that. It's at page 1066, but the relevant parts I'm going to talk about are at page 1072. That's Article 14. So 14.1 required disclosure of all assets exceeding $10,000 in the normal way. And then 14.2 asked the first respondent to inform within 4 days any the three subcategories of 14.2, any onward dealings with the funds, the current value and location of the sums, and the current value and location of traceable proceeds of the profits. So that was these are three categories of information, and there were a couple of steps in the order as to what needed to be done. The first is the normal information provision within 4 days. Paragraph 15 then consolidated that, which is standard provision, that 7 days after that, those three categories had to be verified on affidavit, all that information. And then paragraph 16 further said that the affidavit needed to be accompanied with any documentation recording or relating to the three categories of information in paragraph 14. I'm just making that point to sort of preempt a point that I think my learned friend is saying, his skeleton argument. He says, I think, that to the best of his ability, which is mentioned in 14A, somehow dilutes the obligation to comply with that order. But it doesn't. It's the first step is you notify, you then have to swear an affidavit, and then you have to produce all of the documents that are relevant to that, to those categories of information. That is an order for production. It's a perfectly standard order. And the reason for it in the context of a proprietary injunction is to enable us to locate assets, to trace the assets, to find out what's happened to our money. The next sort of background point I'd make here, I'd refer you to the rules of court. The relevant rule is Rule 28. And I'll just turn that up now. It's in the bundle at page 7515. And turning to paragraph 28.4 or Rule 28.4, it says copies of documents must conform fully to the originals. Any original must be presented for.
Sorry, my bundle doesn't go to 7514.
It has been inserted, I believe, over the weekend.
Oh, well,
this morning, I think. In fact, about an hour ago.
Well, that's very helpful. Okay, well, I'll have to just get a separate copy of the RDC up.
I can read you. It's two very short paragraphs.
Yeah. Okay. Well, I've got the RDC up now anyway. Okay. So what do you want?
28.4. A copy of any original must be presented for inspection. A copy that contains modification, obliteration, or other marking or feature is treated as a separate document. Parties should not redact documents which they produce without the agreement of the parties or the permission of the court. And then 28.5, a party may inspect a document mentioned in a statement of case, witness statement, summary, or affidavit. So those are general points, the order and the rules. And I'll move straight from that to the bank accounts, Your Honour.
Yes.
So what we got, it wasn't within 4 days, or it wasn't even within 7 days. We got these bank statements on the 30th of April, which is 2 months after the original order. We got bank statements for 3 bank accounts, one with the second respondent, one with the third respondent, one with the fourth respondent. And we got a letter, which is at page 5263, saying the bank statements have been redacted to protect, one, commercially sensitive information, and two, transactions not relating to onward dealings on the grounds of irrelevance. So rather than the original documents, what we got here is what Mr. Britton says is the only.
Did you say 55263?
This is the letter of the 30th of April.
It's not my page, 526.
Oh, I've got the wrong.
I have.
It's
I did bookmark the letter. Let me just find it. There we go.
5623.
5623. I've got it.
Yes, that's another similar letter, but not the right one.
5623. Yes, I have it.
Yeah, so it's the subparagraph B there. Bank statements have been redacted to protect confidentiality, etc., etc. So we only have 3 of the bank accounts. We know there are lots more, and they've been heavily redacted, and that's just not in compliance with the information provision in the injunction. Now, looking at what Kroll have said about this, they've had limited time to look at this because it only came in on the 30th of April. So they've provided a brief report of what's missing, basically, all the obvious things that are missing. And I can turn up that at 7300.
This is the 9th of May report, isn't it?
Yes, Your Honour. So put this in context, Kroll were finalising their main report up until the 2nd of April. These bank statements came in on the 30th. They weren't really able to analyse them in time for the main report, but they have produced a short, brief supplemental report. I'm just going to turn up a couple of paragraphs. 3.1.1, these are general findings. And I think it's obvious when you look at the statements, there's a significant amount of redacted material coinciding in the period between the receipt of the monies and transfers. So we can't really work out what's happened to the money. And 3.1.2, many of the transactions have transaction references when no beneficiaries were identified. So there's a lot of payments going out and we have numbers or reference, but we don't know who to. Those are the 2 headline points. And then if we look at the 3 banks that are actually involved in this, I'll take them in turn. The first one is ADIB. Looking at Kroll's report, paragraph 3.5. And what you see there is that we know that $200 million was paid in to one of the ADIB accounts. But we've subsequently found out that there are 5 other ADIB accounts, and we don't have those statements. So that's point number 1. Then looking.
How do you know? How did you say we subsequently found out? How did you find that out?
Well, we found it out by a number of reasons. First, the onshore courts wrote to all the banks, and they wrote back to us, giving us, as part of the execution onshore, where the accounts were and how much was in them. So that's number 1. And then Mr. Britton, after that, made another statement saying that he'd forgotten to disclose a couple of them. Some of them had been closed, and he, omitted that as an oversight. So a combination of the onshore attachments and then Mr. Britton's evidence, we have a fuller picture. There are much more than 3 accounts with those 3 banks.
Okay.
Then just briefly to 3.6.4. It's redactions again. We look at, it looks like 84.55 million has been paid out, but we don't know where because the statement's been redacted. and 3.6.3 just above that, similar point. We see large amounts of money with no beneficiary details or payment details given. Just turning to Mashrek, that's at page 7303. We know that 227 million came into Mashrek, and again 3.8. We've subsequently found out there were more Mashrek accounts, foreign currency accounts. 3.9.1. Here they say actually the bank statements that they got from Mashrek can't even fully explain the money coming in, let alone where it went. So there's something missing there. 3.9.3.1, what they can see from the Mashrek accounts is transfers of $70 million to other DMCC accounts. So there is a lot of internal transferring going on. And then 3.9.4, the same point in relation to Mashrek as to Adib, redacted line item transactions, and that's $109 million, and not an insignificant amount that's been redacted. I'll skip to ENBD, 3.1.1. Again, says there were other ENBD accounts from the one that was initially received the money, and these have been closed. I think it's agreed that they've been closed, but Mr. Britton didn't realise that when he made his first asset disclosure, but he's corrected that now. But 3.12.1, I think they say they can't find or they can't trace how the money has come in and where it's gone. So that's a sort of synopsis of what's wrong with the disclosure. We don't have all the bank accounts, number one. We don't know where a lot of the money's gone because it's been redacted. Yes, so looking at that in the round, it's plain that that's a problem. And then the second problem is redactions to the payments out. So a lot of the payments out have been either redacted or we've got a reference number but no idea where the money has gone. Now, the banks have given the first respondent payment advices for every one of those payments, and Mr. Britton has actually exhibited some of those. So we've got 20 examples of payments going out with sufficient detail to know exactly where the payment has gone. So that information is available, and we say it should be provided as part of the order in relation to onward dealings.
Sorry, payment advices, yes.
Yeah, yes. Your Honour, I can give you one example of that.
Well, just let me get the note. So you have 20 examples of payment advices, and you want a full set. Is that what you're saying?
Well, what we've said is that will help explain the gaps. We don't obviously want every payment advice from every account, but we've suggested that anything over $100,000 should be exhibited. And if you want to have a look at what one of those looks like, I can take you to one in the bundle.
Okay. Right, example.
Yes, 2321, for example. That's a payment advice, a Mashrek bank payment to carbon resilience of $10 million. It gives full details of the amount, the beneficiary, etc. And you can see exactly where the money's gone and so on. But so we want a full book of those so that we know where all of our money's gone. That's really the none of it. And just put simply, I think there's a couple of objections that my learned friend has raised. He says we can't do this because it's all confidential. Well, I say that's not right. If this is our money and we're entitled to trace where it's gone, it just cannot be said that where it is gone is a confidential matter. The second one is he says he's redacted all this stuff because it's not relevant. Well, with respect, Mr. Britton cannot be the judge of that. It's all relevant as far as we're concerned because it's all about the onward dealings. And I think the third point in my learned friend skeleton is the let's decide it all later on a case-by-case basis. And I think that's obviously unworkable, and it's kind of effectively kicking it off to the long grass. And the idea that we go through each of these and work out whether we're allowed to see each one is just not workable at all. It's not burdensome to produce this stuff. They already have it. In fact, the burdensome part of it is doing the redactions, which shouldn't be done at all. So we need that information. It was ordered to be produced, we say, months ago. So I'll move on to the second sub point then, which is securitization documents, Your Honour.
Yes.
So all we've been told about this process, as Your Honour will know, is in two short bits of his affidavit. The first affidavit, paragraphs 46 to 50.
But can I ask you this? If in the light of the undertakings, and if the securitization is not going to proceed until I finally determined whether the injunction should remain in place or not, what is the point of further disclosure in relation to securitization?
There are a number of points to it. I think the first point is that it is relevant to onward dealings because we want to know exactly what's happened. The second is it's relevant to risk of dissipation. And the third point is that, in fact, that what I'm getting from the skeleton, at least, is that they still want to proceed with this. They're incredibly asking for the court's blessing for this to be continued. And there's no proffering of any undertaking in my learned friend skeleton, but I'll come back to that because that was the last point that I wanted to make. But the other point is that some things have been mentioned in the affidavits, which go into a little bit more detail, but when there's no exhibits attached to that, so I'll come into that in a minute. But for example, if you look at his first affidavit in paragraph 47, page 1544. Sorry, yes, it's page 1543, paragraph 47.
Yeah.
47 and 48 talk about an extensive process involving extensive valuation reports and related evidence to support the restructuring, a process that's taken some time. And in paragraph 48, they say that that's all been going on in 2024. That's mentioned in the affidavit. We've got the right to see that under the rules that I've just shown you. And what is produced is nothing to do with any of that. But you know, you will remember that what concerned us about this is the idea that assets were going to be sold to an undisclosed entity before the return date. And if we look at Mr. Britton's second affidavit, paragraph 151, 3787. Sorry, again, I'm one page wrong. I think the bundle's changed since I did it's paragraph 3786. But Aria is no longer in control of the assets. Aria Dmcc is no longer in control of the assets. The assets have been already transferred to the fund or will be.
Sorry, which paragraph are we looking at?
151, Your Honour, I'm sorry.
Thanks. Okay, carry on.
So that the point of this is the utter confusion about which party owns the assets. It's a point that you've picked up on several times in your reasons and judgments, Your Honour. But that was the point that was of concern to us. That the idea seems to be that the return date will come and they will say, well, it's not. We don't have any of the assets anymore. We've given them away to the fund, and they've given them away to someone else. We can't have this continuing until we know what's happening, and until the return date has been determined. And that was a concern that preyed on your mind, Your Honour, when you made the securitisation order on the 14th of April. I'll not go through that, but I can give you the page reference to what you said.
Yes.
You noted lack of clarity in.
Sorry, just give me the page. Give me the page reference.
Yes, so 1344, 1345, and I may be I may be one page off here because it's the bottom of 1344. Yes, the bottom of 1344, 1345. You noted a concern about the evidence as to who owned the assets in the first place. 1394, you raised a concern about the speed at which it was being done and the idea that it was being done before the return date as a risk of dissipation. And then at 1396, at the bottom of page 13 of the transcript, you said, of course, it wasn't for you to decide about whether it was an ordinary course of business transaction, but you were concerned about the complete lack of evidence about the ownership structures, lack of detail on the securitization process, and the ambiguity of the evidence, etc. So that's where we left it on the 14th of April. But that was not the end of the matter for the respondents, because on the 21st of April, and I'll turn this up, 6300, they have said, I think at the bottom of that letter, however, where is it? Yes. We consider that the fund can proceed.
Sorry, where are we looking?
Paragraph 5. But I think before that, they make the point that the fund is not a party to these proceedings. And then they say this is paragraph 4, the first respondent has no role in the management of the fund. So they're saying, okay, you've injuncted the first respondent from carrying on this process.
But he's the CEO, isn't he CEO of the administrator of the investment manager of the fund? Sorry, not the first event. Mr. Britton is the CEO of the investment manager.
Well, we're getting conflicting. He's without question the director of the respondent. He's the investment officer, they say, of the fund, and I think he's the director of the company that is the manager of the fund. But in reality, it seems that he's the one driving this process, and the idea that okay, this plays into the point of who owns the asset, but this is nitpicking, and it was only when after that we threatened to go back to court again that we got these undertakings from Mr. Britton, and even those were phrased in a sort of best endeavours. I won't do anything, and I'll do my best to make sure that the fund doesn't do anything. And then we're back to what exactly do we know about this process? Because we don't have anything about the underlying documentation. We don't have the extensive valuation reports that were happening in 2024. He says he's got that information in 2024. And let's look at, the only thing that he's produced are two pieces of paper dated 2025. You'll see that. I'll not go through those, but they are an engagement letter.
Can you give me the references, please?
Yes, it's 5357.
5357.
That's an engagement letter, not from the fund, but from the first respondent in March 2025.
Mm-hmm.
And then we have sheets 5363 to 76, 5363. And these have got lots of blanks, but they're the proposals for 3 assets, I believe. They dated 2025, not 2024. And one of them lists, well, so that's it. We just have a couple of pieces of paper. We don't have this extensive information, and that doesn't answer the concerns that legitimately have been raised about what's going on and why it needs to be done, and why on earth it would need to continue. So the concern is paragraph 160 of my learned friend's skeleton argument. You'll see this from the way it's been crafted. It's page 7284. And again, it's this that's troubling, actually. The fund is not a party to the proceedings, and it says the assets to be securitized are owned by the fund, not DMCC. Well, we don't, they're owned by, we say they're owned by us, Your Honour, and there's certainly no clear evidence of which of these Aria entities and how they hold these. So that's problematic. And then the second sentence, the last sentence, is extremely problematic because it says the effect of the 14th of April cannot be to restrain either the fund or Mr. Britton, brackets, in his capacity as investment advisor from taking steps in supporting securitization. So they're still trying to carry on with this by the looks of it, and we don't know what it is, and we don't know why, and that is problematic. So that's that. We need full information on that, including all correspondence with the agents. It's been mentioned in affidavits, it's plainly relevant, and if any clarification is needed, the clarification is needed that Mr. Britton will be in contempt of court if he continues down this path. I mean, how many times does a court have to tell you not to do something before you accept that you can't do it? It's a pretty clear principle in my submission. So that said, I'm sorry, I should deal with the objection. He says it would be disproportionate and unreasonable for him to provide this information, and that's obviously wrong. I mean, you want to raise the concerns. We have the same concerns, and we need to know what's happening there. Finally, I'll turn to the electronic documents, which I hope will be the quickest part.
Yeah, you've got 5 minutes on the timing.
Well,
my calculation.
So again, the reason for this are the concerns that have been raised by Your Honour and by us about a lot of the documents in this case. I'll whip through the concerns. First, the ownership. Your Honour, you've said on a number of occasions that you are not clear as to what's being said about the ownership of these assets. And I can give you references to that. The return date hearing transcript, paragraphs 67 to 70. Bundle page for that should be 101099. So that's number 1.
Sorry, just give me the reference again. What on that page? What am I looking at?
You raised concerns about who owns the underlying Aria companies.
Okay.
On subscription forms, there's several versions of those being put forward, and Your Honour picked up the discrepancies of them. That is the same. The return date hearing, paragraphs 33 to 37, and the bundle reference should be 1091.
Mm-hmm.
The share register, Your Honour, interrogated that point extensively at the return date hearing, and your concerns are reflected in paragraph 50, page 10095, and paragraph 69, paragraph 1100. We are entitled to inspect native electronic copies, the originals of these documents. We made the application 2 months ago to get them, and we still haven't got them. In fact, Mr. Britton agreed that he would send them, but then again, in that 30th of April letter, he said it would be too difficult for him to do so. And Your Honour, that's nonsense, because it's obviously easy to give the originals of a document, easier that is to scan it and copy it and so on. That reference page 5623. And if we look at the crawl analysis as well,
if you just give me the references, you've got 2 minutes.
Yes, page 7305, paragraph 4.3. I'd ask you to just take a look at that because it summarizes, there's a table.
Paragraph, say again.
4.3.
Yep.
It summarizes basically that we just don't know what the original source of most of these documents are, particularly things like Word documents have been provided in PDF, documents have been provided as scanned copies.
Yes, I've read all of that. So
just finally, I'd like just to turn you to the draft order that we seek, which is at page 7170. And I think that summarizes everything that we're after, following what I've just said. And it's an amended version of the order. So the first paragraph, the electronic documents, there's a schedule of them, a modest schedule of them attached, but that's what we want. The second is all of the bank statements between Mashreq, from Mashreq, ENBD and Adib, and scroll up a bit, please, in unredacted form. And then thirdly, the payment invoices that we asked for over $100,000. And thirdly, that the securitization documents, finally, the securitization documents should also be provided in native form, preserving the metadata. So that encapsulates everything I've said
yes.
What we want. Thank you for your patience.
Okay. Thank you. No, thank you for being spot on with timing. Okay. Right, Mr. Montague Smith, you've got 45 minutes.
Thank you. I've set a timer running, so I will move quickly if I may. There's one preliminary comment that I make. We do object to the way that this litigation is being conducted, and we object to the way that my learned friend puts this application. My learned friend's approach has been to attempt to ambush the defendant at every turn. One would expect an applicant for a freezing order to behave in an even-handed way, but what we are seeing, I'm afraid, is exactly the opposite. You had that with the last-minute introduction of a incredibly lengthy report from Kroll, and then resistance to any attempt to put in evidence in response. Quite remarkable. We say that the only conclusion that you can draw from that is that they are that is a deliberate strategy, and it continues today. It's compounded in two ways. First, my learned friend refers liberally to that Kroll report, which was put in relation to a different application, to which we've had no real opportunity or any opportunity to respond yet, and yet he relies on it in support of his submissions in front of you today. That's the first point. The second point is that you were taken today, just now, to page 7300 of the bundle, which includes yet another Kroll report that, by the way, was served after hours on Friday night. So deemed served this morning, just about 10 minutes before this hearing started. And in that, it makes a series of allegations, and my learned friend relies on those, and I've got no way of dealing with them. And the other point there is that in relation to this particular application, my learned friend essentially undertakes a roving exercise in disclosure. It's continually changing. And so what is happening in this claim is that my learned friend makes a series of allegations. We seek to answer them, and then we get answers to those allegations, which are new allegations. It's a continually moving target. And what is often said is that there are red flags or hallmarks of fraud. To be clear, that sort of language, what does it mean? What it means is these are primary facts on the basis of which we can make an inference of fraud. It is trite. The respondent needs to have proper notice of those sorts of allegations and that sort of case. Doesn't mean a party can simply say the word fraud and then just keep adding on, layering on new allegations, which it said are consistent with that fraud. Where an inferential case of fraud is advanced, the accusing party is required to set out each and every fact relied on in support of that inference, and then explain why they say those facts are only consistent with fraud. So we object in the strongest terms to the way that my learned friend is trying to advance this application. And the other aspect of this is that the claimant has simply stopped cooperating with the defendant altogether. So, for example, we were not even provided with an index for the bundle for today in advance of the bundle being put together. So what you have is an 8,000-page bundle to which my learned friend has just been adding when he feels like it. So he's not
I'm
applied.
sorry, no. That last point is definitely wrong, because I received an email in which your solicitors were sent the index, and I know that to be wrong. So I'm sorry.
The index came with the bundle. The index came with the bundle. If it's being alleged that the index was sent prior, that's just not true.
I got the index this morning. But having said that, of course, I have the access to the case management system, which does index everything.
Yeah, my point is that there has been absolutely no attempt to refine what is in that bundle, and instead, what's happening is my learned friend has just added things to the bundle.
Yes, well, I take the point.
So you've got a Kroll report, which my learned friend has not only added to the bundle, but he's referred to it in his skeleton argument. It's in his reading list. And yet the report was served sometime after the skeleton. It's quite astonishing.
The index was sent in the form last Thursday.
I really don't. I don't think we should be taking the time up with discussing it. I got the point that Mr. Montague-Smith has made.
Right.
So the first point I wanted to make at the outset of the application is that there is no suggestion. My learned friend implicitly suggests that my client is saying, well, because this is all in dispute, we're not going to comply with the order fully. That is not accurate. There's no suggestion that the defendant is somehow deliberately withholding information or thinks that it's entitled to withhold information. So we accept we have to comply with the order that was made. And the order is to comply to the best of their ability. My learned friend says that somehow waters down the effect of the order. It doesn't. It's in the order itself. You can see it on page 1071. This is not a straightforward task, given the time that has passed since the transfers were made. It is extremely difficult. 4 years has passed, and there are a lot of transactions. The defendant has produced very substantial documentation already. And there are concerns about where this information will end up. Your Excellency's already given blanket permission for the claimant to use any information obtained in these proceedings in what has been referred to as, quotes, the relevant proceedings. Those are the 2 Hong Kong claims. So this is becoming a glorified disclosure exercise for the purposes of those proceedings. Not only that, the claimant is rather stretching that permission, we would suggest. They made an application for a receivership quite recently over the fund in Hong Kong, and in doing so, they relied on the information. They made the application in the, quote, related or the relevant proceedings. Now, no doubt, Your Excellency made that order, or at least accepted the undertaking in the terms that you did, on the basis that the information from these proceedings could be used in the existing claims that were in front of the Hong Kong courts, but that's now being rather expanded out. And I don't know whether it was in Your Excellency's mind that there might be some new remedy sought in the way of a receivership over the fund in Hong Kong, relying on proceedings against DMCC. but that is what's happening. There are other concerns about the use. Mr. Britton identifies them in his evidence. If we can take you, please, to 5333. And this is Mr. Britton's, sorry, I can't remember which one it is now. Mr. Britton's fourth witness statement. And it's paragraph 20 to 23. And I'll just flag those for your reference. But in essence, part of the problem here is the involvement of Mr. Justin's son, who attended last time under the acronym Bob.
Yes, I went through all of that.
I'm grateful. So obviously, Ms. Lee asserts that she is the beneficial owner of Techteryx. That is not the general received view. Now, I understand that the internet can be wrong about things, but yes. What he has done is he has denied all involvement in Techteryx over a course of time. That's page 5346. And despite that, he attended last time. We don't know whether he's in the call with Loeb and Loeb, who appear on the hearing call today. We simply don't know. But it is what we do know is that Mr. Sun is behind a campaign to attack FDT about this, and he's aimed that campaign at Aria, and he's aimed it at Mr. Britton, and he's aimed it at Mr. Britton's wife. And what he's done is he's announced a $50 million bounty for the recovery of what he calls the missing funds. So he is apparently offering $50 million to the world at large to help recover what he says are the missing funds in relation to this claim. You can see that article at page 5348 and 5348, I believe. Let me check.
Mm-hmm. Let me have a look.
Mm-hmm. 5439. It might be 5349.
No, I've got it. It is 5348.
Thank you. So what we say is this is not normal commercial behaviour that is going on here. Mr. Justin's son has also declared FDT insolvent. That has caused it to lose its dollar peg and has resulted in defamation proceedings elsewhere. So there are real concerns about the way in which documentation that is produced in these proceedings will be deployed. And we do say the court should not allow this to degenerate into a glorified disclosure exercise. If Your Excellency orders us or the first respondents to produce further documentation, make no bones about it, we will comply. That is absolutely the case. But that it needs to be precise, it needs to be justified, and we need to have an opportunity to consider it and respond to it. What you cannot allow is what we're having, which is an iterative roving disclosure application. The claimant is presenting a shifting target. The order actually applied for is at 5280. It's not the one you were shown. And you can see at 5281 paragraph 1, they want electronic copies of certain documents that are subsequently defined. Then you've got the reference to the bank statements. And then paragraph 3, which we come on to, is about securitization. But it's any documentation which evidences steps taken in relation to the proposed securitization. Just pausing there, one of the problems there is the complete lack of particularization of that. So we heard today, for the first time, what my learned friend wants. He wants valuation documentation that's been undertaken. Now, there is valuation documentation out there as to which of it was obtained in relation to securitization and which of it is just valuation evidence otherwise. We simply I don't know, but he has that. We know he has that because Kroll has looked at it and said it doesn't stack up, and we will deal with all of that. But he wants also to add a fourth category, which was not seen in advance of my learned friend's skeleton argument. And he says, and also now he says that we hear orally he wants payment advices as well. So we've not heard that before. So I'm supposed to argue in the 45 minutes, the 36 minutes I've got left, about an application that was not made, that he has argued on paper and he has known about in advance. We suggest that is procedurally unfair, and Your Excellency should say enough is enough.
Yes,
They
I
don't
mean,
have
I
permission.
took a very simplistic view, perhaps, on the securitization, because I thought it wasn't going to go ahead until we've determined the injunction.
All right. So and the way that that has been put as well, it is totally unfair. So as we understand, so firstly, we have real reservations about the fact that that application was made ex parte. We didn't apply to dislodge that order, but there was no justification for not telling us about that application. We told my learned friend about the securitization. It was pleaded by them in Hong Kong. They pleaded it. I said that at the first return date hearing, I said one of the problems with this order is it's preventing securitization going forward. My learned friend said, well, we don't think that it's interfering with securitization. We were
But the
always
purpose of
upfront.
securitization is to allow FDT and Legacy to redeem.
It's got two purposes. One is to de-risk the whole exercise, and the other is to allow them to redeem. Yes. So
The redemption was something that concerned me.
And I understand, and so the product of that securitization, I can see that you might want us to hold on to that, but why on earth we should be stopped from doing the securitization, we don't know. But that's fine in relation to DMCC, and I don't challenge that. The question is whether or not this court can bind the fund.
Well, then the question is whether, well, let's take a worst case scenario, which obviously you deny. But let's take the most extreme case that the claimant is putting forward, that securitization is effectively the sale of the assets to an unknown and unreachable party, to ultimately to defeat any tracing remedy that may ultimately be granted by the Hong Kong courts. If that were so, then both the fund and Mr. Britton personally would have an accessory liability.
If it's the fund, no, but only if it's the DMCC that's doing it.
Well,
but can I just? I'm sorry, I'm under time limit. But what I'd understood from Your Excellency's reasons previously is that the only thing that the concession had been made, that the only thing against which the order bites are assets directly held by DMCC. Right? That's at page 1099.
Yes. That's all that could bite.
Yes, so paragraph 66. Right. So I'm not asking Your Excellency to decide today, are these assets that are going to be securitized held by DMCC or held by the fund? What we need to understand, though, is in principle, what does that order bite on? What does that order prevent the securitization of? If it's DMCC assets, all well and good. We don't intend to securitize DMCC assets before the full return date.
What if there are assets of which DMCC was a constructive trustee?
Well, but DMCC was a constructive trustee.
Yes.
But all right, let's go back to the order. So the reasons for Your Excellency were, in my judgment, Mr. Holloway's submissions that Aria DMCC is not the trading entity renders Mr. Montague-Smith's point moot. Mr. Holloway appears to be conceding that Techteryx would have no claim to the assets of the trading companies. So the logic behind that is that the tracing goes into the assets of DMCC and no further.
Yes, the logic was that the tracing went into the shareholding, the ultimate holding of the shares in the trading company.
Yes. So insofar as shares are held by the fund and not by DMCC, then the logic would indicate that the order doesn't bite against them. I mean, that's the only way to make it consistent. So in other words, Your Excellency may say, I can't tell you whether or not an asset is owned by the fund or by DMCC, so I'm concerned about giving a blanket authorization. But we're not asking you to decide that question. If the answer is the fund owns the assets, the fund, not DMCC, then our position was, well, how can the order that's been made restrain the fund from dealing with that?
Yes, but they may say that insofar as any assets were transferred from DMCC, which was the recipient of the money, it was done in breach of trust. That That's their case.
Yeah, I understand that, but the effect of that,
But then that
presumably
makes
then,
sorry.
doesn't that mean they need to get an order against the fund?
They would need to get an order against the fund too, but it would also mean that the fund could have an accessory liability in these proceedings.
Like,
It could.
right.
I mean, we're talking theoretically.
No, but that's not the question. The question's what the order requires.
Yes.
So we do need clarity on this. I wasn't going to deal with this in the context of this application. But look, if you tell us that we're not allowed, that the fund, somehow you're able to say the fund cannot move these assets around, if that's your decision, then we won't do it. But it's not. Okay. That's the logic
well, if you
of
want
that.
to come back to it
if I may,
in a different time slot, that's fine, because it is a very, very important point.
Understood.
Yeah.
So the application. Sorry, I'm a bit low on time now.
No. And it's my fault for interrupting.
No,
maybe it'll be a bit more liberal with the timing for both of you.
That's very kind, thank you. I've shown you the application that was made. The response to the application, we would suggest, was constructive. 5327. Don't know whether you've seen this evidence. If you managed to do the pre-reading, then you will have seen it already. But paragraph 5.
Sorry,
Mr. Britton, 5327.
Paragraph 5.
Correct. So he goes through the documentation and explains what can be provided and what will be provided. And it is subject to some restrictions. And the first is in relation to bank statements, that those will be redacted. Now, I'll come on to the redactions, but that's not the only complaint. There are two complaints, essentially, or three complaints in relation to bank statements. One is they just want to see all our bank statements. Two is there's been redaction. And 3 appears to be that you cannot see from the bank statements the narrative of who's actually received it, because people are identified by codes and those can't be interpreted. In relation to securitization, he said, well, we'll provide some further documentation when it's received. And then electronic disclosure said, we'll provide the originals of the documents. But it did go on to just summarize what has already been provided, and you see that on page 5329, paragraph 11, which includes in the first round of evidence a 537-page exhibit, second round of evidence a 1,445-page exhibit, and then the third round of evidence, which is referred to at paragraph 16, a 684-page exhibit. So substantial documentation has been provided, and also you may have seen the third affidavit of Mr. Britton, which provides answers to many of the questions we suggest that were raised by my learned friend ad hoc in the first hearing, and also by Your Honour in your reasons previously. We don't have time to go through all of that. And I note for your comfort that Mazars has confirmed that audits are underway. So just stopping and pausing and thinking about where all of this goes from my learned friends. He says, oh, it's all a big sham and no one's ever going to be able to prove otherwise. Mazars, whose reputation cannot be doubted, is undertaking the audits. And in that they have obligations, regulatory obligations, of professional skepticism and so forth, to look through all of this. You'll see the letter from Mazars at page 4420. The deadline or the expected response or production of those audit reports is going to be the end of August. If we go down to paragraph 29 of this statement, which is on page 5334, you see Mr. Britton deals with what there is in relation to bank statements. And at A, he says there are 13 bank accounts with the various banks, and of those 3 received the payments. So you see that at 29A. And what he's had to do, as he explains, is he's had to match those payments and then payments out of those accounts with payments into other accounts, and then redact the ones which are not relevant. And you'll see that at paragraph E. So as I understand it, the redactions are only for relevance. And then paragraph 30, the DMCC payments were not made into any of the other 10 accounts. And he explains his understanding, which is that to the best of my knowledge, once received into the target bank accounts, the DMCC payments would not have been transferred to or between the other bank accounts. Now, one of the things that is said in the new Kroll report that was served on Friday, but we haven't had an opportunity to look at properly, one of the things that is said is that some of the money paid out might have found its way back in, or might have gone to other Aria DMCC bank accounts. We are happy to check that, and if the other accounts are affected, produce those accounts by reference to a narrow time window which would apply to that. But the position as it stands is that we have produced substantial bank statements. In relation to the other accounts, it was said, well, Mr. Britton had failed to disclose some of those accounts, realised that late, and it was only discovered all after the event by my learned friend. That is not a fair account of what happened. He disclosed all the accounts which he was obliged to disclose. There were errors, that is true, in relation to ENBD Bank, which had been closed. So at 3716, you'll see the statement of the accounts that were disclosed, and what he has said then, what the reason there are other accounts which were not disclosed, and you'll see this at 5883, paragraph 23A, and this is in relation to the attachments application. He explains why there were other accounts. So he says 5 lines down, I note that Aria DMCC holds additional accounts with Adib and Mashrek, refers to Ms. Jabala's second witness statement, raising a question as to why the 2 additional accounts with Mashrek were not disclosed in the updated asset disclosure list. The other DMCC accounts were not required to be disclosed because they had at all relevant times 0 balances, and then goes on. So and deals with the which we'll come to, the effect of the attachments application. So what's happened is that the first respondents undertaking an exercise in redacting irrelevant information. And we say on any view they cannot be entitled to see irrelevant information. The only responsive evidence to that is at page 5400. And if one goes down at Ms. Jabala's statement, page 5402, paragraph 7.2, they say they don't accept that we've made appropriate redactions. And what is cited as a summary is a statement that I made in the last hearing, that the subsidiaries and everything they own are derived from the monies that went into the fund in the first place. Now, that was necessarily a pretty broad brush statement before the exercise that we're dealing with, but also that was not a statement about the position as it was when the money came into the account. I think the point being made in this statement is that what I said suggests that everything in the account in the funds at all times was referable to these payments. But of course, that's not the position at the time of receipt of the money. It was an ongoing existing fund at that time. And so there are other payments which are not relevant. But ultimately, the question is a factual one, which is whether the material redacted is in fact relevant or irrelevant. We don't accept that it is relevant. And the problem for Your Excellency today is that there is really no material on the basis of which my learned friend could make that case. We don't have the bank statements in the bundle. The claimant has chosen not to include them. Didn't ask us about what should be in the bundle, just didn't include those documents. And so instead, what my learned friend does is he continues to pursue his ambush tactics. First, you've got this late served Kroll report, which he's referred to, as I say, both in his reading list and in his skeleton argument. And he didn't serve it until later on. We've had no opportunity to respond to it. We were not made it aware in advance of it in filing our skeleton argument. My learned friend knew about it, deals with it in his skeleton, didn't tell us about it, doesn't explain that, doesn't seek permission, just puts it in. And the second, and you see this from my learned friend's skeleton argument, paragraph 10 of his skeleton, he just writes into his skeleton argument, sorry, page 10, not paragraph 10. He just writes into his skeleton argument the evidence. what he claims to be the extracts from the bank account, which is copied and pasted into his skeleton. So he's literally giving evidence in his skeleton argument, which he must know full well is just unacceptable. These are court proceedings, Your Excellency. The powers you wield are significant, and litigation simply cannot be permitted to be conducted in this way. So we do suggest that a little bit of discipline needs to be imposed. I mean, ask one question: how am I supposed to deal with this? How could it possibly be fair to deal with it in this way? There may be good points here. There may be bad points here. So we say you could just choose to exclude all this new material and say, well, it rests with Miss Jabala number 2. Or what you can do is you can give us some time to actually look at this and respond to it. Otherwise, what's happening is my learned friend's effectively just seeking another ex parte injunction. So our primary position is, therefore, if you are going to let them deploy this new evidence, you should give us a chance to consider it and respond. And it may be that we can provide assistance. And I've got instructions on that we may be able to do 2 things, and we'll do it whether ordered to do so or not, if you think that they would be helpful.
But you already have permission to respond, don't you?
I'm sorry?
You already have permission to respond.
To respond to this application.
Well, to respond to any report served by Kroll.
Yes, thank you. But what I mean is that in terms of this application for disclosure,
okay,
what we say is just give us an opportunity to look at the criticisms that are now made and see what more can be done consensually, and see whether that resolves it. And then, so in other words, you should tip off this application to let us take a view. But what we can do are 2 things to try to help, and this is what we've been able to take instructions on over the weekend. Yes. Number 1, I'm instructed that we can provide a schedule which explains the breakdown of how the payments were used, that will link each payment to a bank entry, or at least try to do so. So in other words, one of the complaints that's made is that the bank statements don't provide enough information because they don't tell you who the recipient is.
Yes.
And they don't tell you where things are going. So we can try to provide that breakdown, I'm told. Okay. And I've seen a draft of it. We would have provided it to you, but we're doing it at pace. And the concern is we produce something that turns out to be inaccurate. And then my learned friend criticizes us because of the inaccuracy. So we may well be able to do that. And if we can, we will. And I think we should be able to. Yeah. The other thing is I'm instructed that if it appears that the initial payments were paid through into other Aria Dmcc accounts, as has been suggested, we will include that in the analysis and will provide further payments for the relevant period. What we say would not be fair is for Your Excellency to grant an order for disclosure of all the statements now, regardless of redaction, regardless of relevancy. And we say that actually, on my learned friend's case, isn't going to help him very much because there's no narrative in those statements. So the right response, we say, is to give us time to respond to the analysis, or to look at the analysis, address the concerns raised, and provide what we can further. Adjourn the application until after we've done that. Then my learned friend can see what we produce, and if he still wants to advance this application, he can bring it back on, but he needs to do so properly, telling us what the problems are that they see, and not in his skeleton argument, orally in evidence, or supported by evidence produced literally after hours, the working day before the hearing. If you're against me on that in relation to bank statements, we say circulation of those statements should be strictly limited to the DIFC lawyers. These statements should not be allowed to make their way into the hands of Mr. Sun, in particular, who's issued a bounty on anyone who helps him find where the money has gone. It's going to lead to, or could lead to, harassment of people who are totally unconnected with this dispute. The other thing is it should be limited to what is actually applied for, not these additional elements. So, for example, the payment advices were never requested. And the other thing is when you actually look at Ms. developers responsive witness evidence in relation to this. If one goes to page 5401, when you look at that evidence, paragraph 6.1, in that evidence, the claimant did not press its request for other bank statements. So if you're going to make an order, it should be limited to what was actually sought and actually in play, until my learned friend submitted his skeleton argument on Friday. In relation to securitization, the short answer in relation to that is on it hasn't gone forward, so there's very little to produce. And your Honour's quite right. Your response to that is not simplistic. It is simple, but it's not simplistic. We have produced some documentation in relation to that. The engagement letter, there's various product sheets, the carbon resilience agreement, and so forth. But it's not, we say, relevant to the issues that are going to be at play in this application. It's ultimately just a disclosure exercise that's going on for ulterior motives, we say. In relation to securitization, the other problem is that the order sought is far too broad. It is totally unfocused. And we've referred to a passage from Matthews and Mallock, which makes good the point that these sorts of applications need to be focused and particularized. So as I mentioned previously, for example, we did not understand that what my learned friend was after were valuation documentation in relation to various of the assets. I don't believe that that's been said before, but there's a lot that's been said, so I may be misstating that. But there are valuations out there. We're going to undertake a proper response to the Kroll report, and it's likely that those sorts of issues will be swept up to the extent that they're relevant in that. So the problems are, first, the order is in relation to securitization is too broad. Second, sufficient documentation has been produced, and third, this isn't relevant to the proceedings. I'll come back, if I may, subsequently to the points that you raised about the effect of the order in due course. But make no bones about it. If you tell us to do something, we will do it. But obviously, it needs to be. You need to be comfortable it's within the limits of your powers. And then electronic disclosure. So I think I've got a few minutes actually. I mean, I won't labour this. The initial request that was made was to see everything in its electronic form. That's page 6214. This is not a usual, in the ordinary course request. One doesn't see this all the time. And so paragraph 5, this is a letter dated 28th of March, and paragraph 5 just seeks the electronic copies of the document's native format in a manner which preserves metadata. And then in Ms. Lee's second witness statement, that's reduced to a narrower category of documents. We see that at paragraph 28, page 5290. And so you can see original electronic native copies of certain documentation which has been produced by Mr. Britton. So you've got copies of share registers, subscription forms, and so forth, copies of various loan agreements, copies of invoices, and so forth. Documentation was then provided on the 30th of April 2025. Now, just pausing there, my learned friend now puts the case as it on the basis of rule 28.4, which says that we're required to produce copies of an original, and therefore that somehow gives him the opportunity to inquire through, not just to the versions of the documents that we have in our hands, but somehow that we have to, so take, for example, share registers. I think what he's saying is we have to go to the fund administrator and say we need the native version of the document that's been produced by the administrator. Or, for example, invoices from Glassdoor. We have to go to Glassdoor and get the original documents that were produced by them. That's not what the rule requires. The rule requires us to give them what we have in the form that we have it. And if the answer is that those documents we have in PDF, then that is it. That's all we need to produce, and that's all we should really be ordered to produce. And essentially, that sort of documentation was produced on the 30th of April, so 12 days ago. And in essence, it's quite difficult to understand what the complaints are at this point, albeit they've been supplemented by this recent Kroll report. My learned friend's skeleton argument, we've got a vague complaint at paragraph 45. And the complaint is about a comment that was made in the letter disclosing these documents, and the underlying passage of that letter, which seems to be the source of the complaint, because it said this is an unsatisfactory approach. It said what we've produced is what it says is the production has been prepared by reference to the electronic documents that correspond to the various exhibit references provided by your client. As such, certain of the documents indicate that they've been modified on the date which they've been received by our firm or saved to our system. So there was a small issue in relation to a small number of documentations, so a small number of documents, as to a slight discrepancy in relation to the quote modification date that you sometimes see on those documents. But there's no particular explanation of why that actually causes a problem, and it only affects a small number of documents. And until Friday, there was no attempt to identify any sort of other complaints, and then we've got this Kroll report. So if this is an inspection process, effectively inspection of documents which we've relied on, my instructions are we have produced what we have. And so where documents were in our possession initially, in the PDF form, that is what's been disclosed. But what we cannot see any justification for, indeed no application for, it is an order that we go back to the parties from whom we received those documents and obtain further versions of the documentation. So if Your Honour considers there's an issue to be dealt with here, again, the option we would suggest would be give us the time to really understand what it is that they are looking for. Give us a ruling that they can have the native documents in the form that we have them, if needs be, but otherwise reject the application. And if the claim is that actually we do have documents in our possession in different form that we haven't produced, then we'll go back and look at that. But my instructions are that is not the position at all. So that's that. That's what I had to say about the information order application. Sorry, the other point in relation to the electronic documentation is that it has to be limited. If it's advanced under inspection, it has to be limited to native copies of what we've actually got and what we've referred to in and exhibited to documents. Given I've got 5 minutes, just wondered, my notes are out of order now, whether or not it might be worth just picking up this securitization point and seeing whether I can explain our position a bit better than I.
Okay, as you wish. If you're within, you've got your time.
I've got 4 minutes.
Okay.
I've got 4 minutes. Let's see if I can do it. I may have to come back in pieces.
Yes, that's okay.
What we'd understood was that Your Honour had on the ex parte for securitization. We'd understood Your Honour had raised the relevant point. Can an order that I make affect the fund? And that's at page 1344.
Yeah. And
we don't see that question was ever answered. So you on that page, Your Honour said The one thing I'm slightly confused about is whether or not, in fact, Aria DMCC owns the assets at all, or whether it's the Cayman Fund that owns the assets, because the issue is that the Cayman Fund is not a party to these proceedings. And the answer that came back further down is, Your Honour, you'd be making an order against Aria DMCC and its servants, agents and officers would be bound to obey that order. Well, actually, everyone would be bound to obey that order, but there we go. And then below that, I was trying to stress at the return date hearing that the evidence on that simply is not clear. And that doesn't answer the question, because the question must be, if the assets are owned by the fund, does the order against DMCC prevent their securitization? This isn't the primary forum for this claim. All Your Honour's done is making, well, all Your Honour's done, Your Honour's made an order against DMCC saying you must not deal with these assets other than in the ordinary course of business. And we've parked the question of whether securitization falls within that category. And my clients are content to go forward on the basis that DMCC can not securitize any of its assets. And the question then becomes, well, what about the fund? Why would the fund be constrained from securitizing its assets? And part of the answer appears to be, well, the fund might somehow be caught because the officers of DMCC would be bound to comply. But that's wrong, because the question is whether or not the securitization of the fund's assets could be a breach of this order. If the order only applies to Aria DMCC's assets, not the fund's assets, and we've been operating on the basis of the concession that was made by my learned friend and accepted by Your Excellency, as I say, at page 1099, paragraph 66, which is that we read that concession as being accepted, or at least the logic of it as being that it is that the order only bites on assets actually held by DMCC. So if, for example, you have Aria Bio below DMCC, regardless of where the money came from, in relation to the, for example, the bitumen plant held by Aria Bio, there'd be no problem with dealing with Aria Bio dealing with its assets. That was the concession that was made. Now, if that is true in relation to Aria Bio, why on earth wouldn't it be true in relation to the fund, which is not owned by Aria DMCC?
The position in relation, for example, to Aria Bio, as I saw it, and I think I use the expression commercial logic, the commercial logic was that Aria Bio itself is an asset. It's not a matter of I mean, it's the level at which you see the asset, and it's a trading asset. So obviously that asset has to keep functioning to retain its value as an asset. That was what I meant by commercial logic. So the asset that the DMCC was restrained from dealing with was actually the ownership of Aria Bio.
Yes. So yeah, understood. But what that excludes is the possibility that because Aria Bio's assets are derived ultimately from money that came in, or maybe derived ultimately from money that came in by way of the payments, that Aria Bio is not allowed to just deal with its assets. It's not in any way constrained from dealing with its assets. So the high point of my learned friend's case must be, well, the fund has money that has come to DMCC, but has gone back to the fund and then has been used in one way or another to purchase assets which are now in the hands of the fund. So why consistency? This is, my learned friend puts it as some sort of outrageous suggestion, but we genuinely cannot understand how it can be consistent with this concession and the way Your Excellency has dealt with it in relation to Aria Bio, that somehow the fund is restrained in relation to its assets. And I mean,
take an alternative. What if Aria Bio says, okay, I'm unconstrained in the use of my assets. I'm going to sell the entirety of my business to an undisclosed entity in Panama that's completely judgment-proof. I mean, how do you think the court might look at that?
No, we don't say that the court would look at that positively, but the logic of it is that the logic of what you've suggested, and then the reason why the proprietary order stayed in place. So my learned friend made a concession on the basis of which he got an order, and the logic of it is that Aria Bio is entirely entitled to deal with its assets as it sees.
But Aria Bio
fit.
is itself an asset, and what if the court were to consider? I mean, this is a different issue, but I'm just testing the analogy. Were to consider that the value was sucked out of that asset in a way which was intended to defeat any tracing remedy that ultimately might be granted.
Yes, I understand that concern, and make no bones about it, that is not happening, and no one's suggesting.
No, I'm not suggesting it is, but I'm just trying to test the logic of it.
No, absolutely. But the problem is that the order comes against Aria Dmcc. So the reason why you have that concern and why that's a concern for this court is because Bio is a subsidiary of DMCC, and it might be said that if you empty the money box, then actually you're destroying the value of Aria Dmcc's asset. Yes. Now, I accept your Excellency is not in a position today to say, right, take these other assets that are owned by the fund, or we say are owned by the fund. Are they owned by the fund, or are they not owned by the fund? You may not know the answer to that question, but we're not inviting you to answer that question. What we need clarification on, though, is whether or not your Excellency is actually saying that one way or another, the fund is not entitled to deal with its assets, whatever they may be. Now, if it turns out that those assets are owned by the fund, if we're confident that that is the position, then we cannot really see why the effect of your order should be to prohibit us to do anything in relation to those assets. Or sorry, I say us. The fund should not be prohibited from doing anything in relation to those assets because they're not owned on the premise. I mean,
do I have anything on the record, because I've obviously only read things in a very quick way at the moment, which explains why it's necessary to undertake the securitization before the adjourned return date?
I can't, off the top of my head, give you the answer to precisely where it is, but my understanding of the position is that ultimately, why is it absolutely crazy urgent? I don't know that you've got evidence in relation to that. What I think we can say is that if Techteryx is wrong and this is not their money, it's not their interest, then we are beholden to FTT and Legacy to deal with them as investors, pursuant to regulatory obligations and all the rest, and contractual obligations. And the court generally should not be doing anything to restrain that unless there's a very good reason to do so. And ultimately, if you want to make orders about the product of that securitization process, or if you want to make orders which are conditional on undertakings about the product of that securitization process, then we can take instructions and find out whether that can be provided. And I can see why you might have concerns about the fund being turned into a transferable note, which is then easily liquidated. But if you want undertakings in relation to the transferable note, we can take undertakings. I can take instructions about whether we can give you those sorts of undertakings, and I'd be surprised if that sort of thing couldn't be organised. But the question is, should you stop the securitization process, which is, on one view, being undertaken on the advice of an experienced investment manager, as the right thing to do for two reasons. One is to de-risk the investment, and the other is to facilitate distributions.
Mm-hmm.
I'm going to get chapter and verse on precisely where that comes.
Yes, of course, that would be helpful. Thank you.
So But what I'd say is, I mean, perhaps my position would be that that's to ask the wrong question, which is why shouldn't I? Why should I allow this to go forward? And the right question should be why should I restrain it? And so you'd have to look at the question of whether or not you consider that it amounts to a risk of dissipation. Assume that I'm wrong, and you can catch the fund's assets. Is there a risk of dissipation in relation to this? And what I'd point out is that the fund and DMCC have been completely transparent about this process all the way along. My learned friend says, well, it's disgraceful. What would be disgraceful or arguably disgraceful is if we'd just gone ahead and done it and not told anyone that that's what we were doing. But we didn't do that. At any stage where we thought there could be an argument about this, what we've done is we've raised it in correspondence. They pleaded that it was out there that this was going to happen in Hong Kong. I raised it at the first hearing. My own friend said there's nothing to stop it happening, and we're working on the basis of a genuine interpretation of Your Excellency's judgment and the concession that was made, and we flagged in advance when this was going to happen. This isn't something that's being done surreptitiously or in secret. This is all out in the open. And if it's going to happen, it's got to happen through a proper securitization agent, and it's got to be backed by proper valuations.
Okay, all right. So let me give Mr. Holloway his 10 minutes.
Thank you.
Well, I mean, I think I should have rather more than that, Your Honour. If we're
You're
dealing with
going to come
question.
back, Mr. Holloway. Mr. Holloway, you're going to. I just at the moment want to hear from you on your disclosure application. We'll come back to. I'll give you time later to deal with the securitization issue more broadly.
Well, I think they're connected, Your Honour, because what you'll see from what my learned friends just said is something that's been going on since 2022. Techteryx have been asking, where has our money gone? And the answer they're getting is, oh, we're going to engage in this securitization process, and we're not going to tell you where the money's gone. And that's exactly what is my learned friend's position today is, I submit we don't need to talk any more about the securitization process because there was no application to set aside that order. There was no application to vary the order. And if anyone's ambushing anyone, it's my learned friends. There's absolutely no. The only thing that is necessary in relation to this securitization process is what Your Honour has highlighted: a complete lack of information about what it is, how it's happening, what has been done. You asked if there was anything in the record about why it had to be done so urgently. The answer is no, there isn't. You also, there's a very interesting discussion, but I point you back to the concerns that you've raised all the way along. The asset picture is opaque at best. The only person who's been instigating the securitization process is Mr. Britton. His name is written on the securitization sheets. And my learned friend is suggesting at paragraph 160 of the skeleton that Mr. Britton should be allowed to continue with this in his capacity as a fund person, but not in his capacity as a DMCC person. That has to be wrong. Now, it's open to either DMCC or Aria, the fund, to make an application to this court, put all the information on the table and say, can we or can we not go forward with this transaction? That application has not been made. We shouldn't talk any more about it. The orders that you made should stand. And I think my learned friends made amply clear why we need the disclosure order on the securitization documents. We need the correspondence with the agents, and we need to know those documents that were happening in 2024. It's pretty clear, it's not broad. Second thing is, I think my learned friend said that we're asking for new matters that were not in the original application. Your Honour, that's wrong. If we look at the application, go back to it, page 5277. If we look at it looks we've asked for all the bank accounts with the respondent banks all the way along. The only reason that we didn't list them all is we didn't know about them all until the onshore court told us. So that's that. In relation to this idea that we've constantly shifted our case, Your Honour, the analysis that we've presented is simply analysing the documents that we got. We got them late. If anyone has presented a shifting story here, it's Mr. Britton, and his story about the asset picture has shifted 3 times. So we're dealing with the information he gives us. We got the bank statements on the 30th of April. That was in response to repeated requests. We've analysed them as best we can. It's not, he didn't put them in the bundle, but it's pretty clear they're all redacted. We're just making a very obvious point that we can't trace through where the monies have gone. So the requests for the complete bank account picture and the payment requests, nothing more than what you originally ordered in paragraph 14, a full account of any onward dealings with the monies. That's what the respondent's been ordered to produce for a very good reason. It's a standard proprietary injunction disclosure order. You don't get to pick and choose the things that you say are relevant there. Red flags, Your Honour, that's not my language, that's your language.
That was my language, yes.
So, you know, if that's inappropriate language, I don't think so. And you know, the application is absolutely no defence to it. These are just basic information which they have. The concerns that, you know, about onward disclosure, there can be no adjournment here. This has been going on for months, and we can't just kick the can and hope that they get on with the securitisation and be done with everything. That's completely unacceptable. So, Your Honour, the case, Mr. Britton's case is changing all the time. We agree with my learned friend on one thing. This order needs to be policed effectively, and the respondents should start complying with it. The documents that we've requested we're entitled to, and they've been outstanding for months, so I'll say no more about that. But I would say that's all that needs to be said about the securitisation process. You know, we don't want this hearing to be hijacked again. I didn't make any concessions at the original return. All I said was we have no idea of the connection between these companies, so they can't sort of prove what they were trying to say at the time, which is that it would be unfair if they weren't allowed to use any of the assets of the trading entities. At that point, we didn't even know anything about this corporate structure. And again, that shifts constantly, and we still don't know. We're still none the wiser about that. So that's all. Thank you.
Okay, so yeah, well, let's start your 10 minutes running now. Then on your since I gave,
I'll give you everything I need to say about that.
Okay, well, that's very good indeed. In that case, let's take a short break. It's 10 to 1 Dubai time, which will then leave us with 3.5 hours. So let's take a break until 1 o'clock Dubai, which is 11 o'clock London. Thank you very much.
Thank you.
I'm glad to see you weren't misled by my mistake as to the time in London. I said it was 11 o'clock. I think, of course, it's 10 o'clock. Forgive me on that.
Your Honour, sorry.
Yes.
I have had my gun tugged in the break for a point that I
Okay.
should have made and didn't make. It will take 1 minute, if I may. I do apologise.
Yes. No, that's okay.
This is my very able, learned junior, Mr. McCarthy, has asked me just to point out that the securitisation documents which have been produced, the letter and the sheets, are all in the name of Aria Dmcc, and just the page reference for that is 5357. So that's
I think I'd seen that point before, and
Okay.
also one of the documents is in has Mr. Britton's name on it, I think.
Yes, that same document and another. The second small point is that it is open to any party who feel that they may be adversely affected by a freezing order, including Mr. Britton, Aria or Aria DMCC, to make a proper application to the court with full information about what they're going to do and why they think it should be permitted. That's never happened. This shouldn't be done on the fly. If they want to make that application, let's have it with proper information. And I think that point was made at the ex-parte hearing. It's on the transcript. And that, I think, reinforces the information request that we've made, because it seems like they're still trying to get the court's blessing on the fly for this. And the final point that the client wanted me to reiterate is that the evidence at the first return date hearing, my learned friend confirmed that all of the assets, all of the monies in the fund were connected to my client's investments, and there were no other investors in the fund. So they're obviously extremely concerned at the idea.
I'm not sure that's completely true. What we do know is that the only investors in the fund are legacy FDT, and I think the evidence from Mr. Britton was that 80% of the assets of the fund are attributable to the 6 remittances.
I do apologise. That's correct, and legacy FTT and so on. But the point remains, they're naturally very concerned about this and in the dark about it. So I'll leave it there. I'm sorry.
Okay. No, that's okay. Right. Let's move on to application number 8. I can shorten matters, I think. I'm afraid, much to Mr. Holloway's discomfort, I'm afraid. First of all, I'm broadly sympathetic to this application. And secondly, I'm not at the moment overwhelmingly impressed with the argument that the fortification of the cross undertaking in damages is relevant to the issue of security for costs. They are two different things, it seems to me, and what's more, they would both simultaneously come into effect if the claimant ultimately lost. So they are not only different, but they're parallel. Clearly, if the injunction were discharged, the undertaking in damages would be given effect, and there would be an order for costs. So I hope I've shortened you slightly, Mr. Montague-Smith. I may have lengthened Mr. Holloway somewhat.
Thank you, Your Excellency. So just then to pick up on, sorry to continue. I think the securitization issue is going to be a rolling debate, but I did want to make clear I'm not making an application in relation to the order that Your Excellency made at the ex parte hearing, dealing just with the securitization, so the sort of second ex parte hearing. We were not invited to that hearing. We should, we say, have been invited to that hearing. Even if it was urgent, there was no reason to exclude us. But regardless, what I am asking Your Honour to do is to provide clarification as to the effect of that order. That's not something that requires an application. That is something that the court will no doubt be minded to do. And the point that I'm asking your clarification on is simply insofar, so does the order prevent securitization of the fund's assets? That's really what we want some direction on, because Mr. Britton is not going to risk contempt. We've made that clear numerous times, but on the face of it, for the reasons I've explained, we don't understand why or how that order can affect fund assets. But there we are. I'll leave it there.
But that's yes. I mean, that the way you put it there is a very interesting way of putting it, because the question then is, what is an asset of the fund?
Well, but I'm not asking you to decide that. We can take a position on that, and that's somewhere where we don't perceive, almost, that there is a risk, because there's a factual question: is it a fund asset? Is it a DMCC asset? And that will follow from the ownership structure.
Well, as you can well understand, that's probably the bit that gives me the most pause for thought.
Well, I understand that, but I think that I'm not asking you to make any clarification in relation to that. What we're
Yes.
asking Your Excellency for is simply an in principle clarification. Does it have this effect or does it not? Because my learned friend's position is it does, regardless of whether it's owned by the fund or DMCC. And that's where the debate really is.
But the debate, it seems to me clearly that if the fund owned assets before the remittances or before whatever, that's one thing. But then, as you say, the devil is really in the detail and the factual consideration as to whether, in fact, what is being securitized are in fact assets of the fund. I mean, that's my concern.
Yeah. No, I can understand that.
And I can't decide.
say,
I can't decide that either way. So I've got to work on. The basis that we are in an interim injunction territory, and so I have to think about it.
Thank you. No, and I fully understand. I think, as I say, all we are looking for is that principled clarification, and if we could have that, it will help me to give advice to my client.
No, I understand. I understand what you're saying.
Thank you.
I'll do what I can to assist in terms of clarity. Okay.
Thank you so much.
So
security. I'll be very brief then, if I may, and perhaps I'll try and pick things up in reply rather than in opening. But having given that, I will move quickly through. So the two stages you're aware of, Your Excellency. First, can we satisfy one of the conditions in 25.102? And second, is it just in all the circumstances to make the order? And the two that we say are satisfied in terms of conditions are, firstly, it's resident outside the jurisdiction, albeit that has a limited impact, and we understand that. But the main one is that they're a company, and there's a reason to believe they'll be unable to pay the costs if ordered to do so. The claimant does not appear to really dispute that those conditions are satisfied. Just to tell you, because one of the complaints is about timing, how this all came about. And you may have seen the account in relation to that. It arose after the order for security for fortification of the $2 million. That was due by the 30th of March. And so what happened was 2 days before that, the claimant applied for an extension of time to make the payment. And it was there that Ms. Lee identified that the money would come from Golden Aim Limited. That's at page 5257, paragraph 11C. And then immediately on the 31st of March, the defendant's lawyers asked for information about Techteryx's financial position, including information about Golden Aim. That's 5821, and there's a letter there. And the responses came back, firstly, that they would take in.
It's all very complicated. I mean, I've read this again. You said they came back saying it's all a bit complicated, and then nothing really followed from that.
And nothing really followed from it. But the point is that the last chase went in on the 8th of April, and obviously a little bit of time needed to be given for a response. There was going to be a response after that, and nothing happened. And so 16 days after that, the application was made, because one of the points that's made against me is a timing point. But we do say that is a bit surprising if the position is that Techteryx cannot actually pay the costs. One would have thought that would also have been something that would be raised on an ex parte application. By the way, my client doesn't have any money and isn't offering fortification, but there we are. The claimant's submissions are in the skeleton. I'll run through as briefly as I may the points that are raised against me, starting with paragraph 50. And the first one is that the fortification that has been provided is sufficient to deal with security as well. And Your Excellency's mentioned that as well. And the short answer to that is that is an attempt to get an implied variation of Your Excellency's earlier order, which is that the $2 million is fortification for the counter.
Well, as far as I'm concerned, they're apples and oranges. And
yeah, exactly. Very good. All right. So the next argument is that it is unjust to make the order, and that starts at paragraph 57 of my learned friend's skeleton, and he identifies 6 points. In reality, that boils down to 3. The first 2 points are about the merits, and I remind Your Honour of the rule, which is 25.110. Investigation of the merits of the case on an application for security is strongly discouraged. Only in those cases where it can be shown without detailed investigation of evidence or law that the claim is certain or almost certain to succeed or fail will the merits be taken into consideration. And my learned friend relies on the Kroll report to say that that demonstrates there's been a very substantial fraud. We've got quite a lot to say about the Kroll report. We'll do it in due course. But the short answer is, absent a detailed investigation of the evidence, my learned friend cannot make out that case, and that is not something this court should engage in. He does also say we've had an opportunity to respond to the case, which Your Excellency has already said we have not. Your Excellency will also recall that there are obviously other prior issues which arise, amongst them how Techteryx can really claim a beneficial interest in the money, or any interest in the money, in the first place. And we would say, if you were going to get into questions of whether there's a clean and simple answer to this case, that's where the clean and simple answer would lie. So if we're going to have an argument about the merits, then let's have it. But I'm not proposing to embark on that. My learned friend stoops to the position in his skeleton argument at paragraph 14, saying that we conceded that his claim on fraud is reasonably arguable. We have never made that concession, and it's utterly wrong for him to suggest that we have made that concession. We say it's not safe for Your Honour to take a view on these issues on the basis of a one-sided account of the evidence from Kroll. My learned friend also says that this is not new evidence. The Kroll report's not new evidence. That is, with respect, also obviously wrong, and I won't labour that point. So that's the first 2 points my learned friend makes, and then the third, fourth, and fifth points, my learned friend says, well, Aria has paid its legal fees. It's entitled to do so. My learned friend tried to get that variation at the last hearing and did not get it. So there was an argument last time about whether or not we should be prevented from using Aria Dmcc's money for the benefit of legal fees, and that exception was maintained. So that is not open to my learned friend either. Again, he's effectively asking you again to vary the order, and in fact he comes on and says you should vary the order, although he doesn't make an application to that effect. And then he says, amongst that, he says that the claim has incurred excessive costs. I'll come back to that in quantum. We dispute that. It's inevitable that this was going to be an expensive exercise, and one just has to look at the 8,000-page bundle that we've got. But that is being exacerbated by the way the case is being presented. It is a moving target. It's effectively a roving audit of the fund that we're supposed to be answering as we go. So we will deal with the points that are raised in the Kroll report. But one of the things I'll be saying to Your Honour later in relation to directions is that we cannot allow this just to keep developing. So my learned friend says, well, now that Techteryx has got an opportunity to respond, we should have a further opportunity to respond, even though he said, well, actually, the court wouldn't be assisted even by Aria Dmcc's opportunity to respond. I'm sorry, I said Techteryx earlier. I didn't mean that, but I think you understand the point. And my learned friend, in amongst these submissions, seems to suggest that Techteryx should have some oversight over Aria's instruction of its lawyers, which obviously is anathema to the principles of privilege, litigation privilege in this context, and is not something that he provides any authority for. So the short answer is there's no application to vary the original order in this regard. There's no change of circumstances which could justify such a variation. The evidence that's before you isn't directed to his request that you make some sort of order varying and supervising my client's use of its legal expenses. And this is just another last-minute ambush that was put into the skeleton argument. But it's not a reason to refuse security for costs in any event. That's how it's presented. And then the sixth point that he makes, 57.6, raises a collection of complaints. Amongst them, he says we're in breach of the order. That is a serious complaint. It shouldn't be lightly made. It is still less likely accepted. We do not accept that that is true. And we've been over some of the ground that's been covered in relation to that. But again, why should that affect a security of costs application? There's also a separate complaint about securitization, but again, as I've sought to confirm, Aria has been totally transparent about that throughout. And so whenever we've proposed to do something, we've said in advance, this is what we propose to do, and given everybody an opportunity to have an argument about it. Paragraph 58 is a complaint about what the form of the order, whether it should be an automatic sanction. I'll come back to that. The next complaint then is at paragraph 60, which is that the application has been made, it's said, too late. We see that as a very surprising submission, and this was the point of taking you to the timetable. So within 3 days, and I believe that's 1 working day of being told that this other entity would pay the fortification, inquiries were made, those were stalled, nothing was produced, and then my learned friend says it's our fault that there's been some form of delay. So we raised the issue as early as we reasonably could have done and brought the application as early as we reasonably could have done. So, and after that, really, the complaint is all about quantum. The costs that have been incurred have been substantial, and further substantial costs will be incurred. The estimate is 1.75 million or thereabouts. That includes costs to date. Some suggestion that it should not, but that would be, we would say, totally unprincipled in a situation where costs are being incurred at pace because of the way in which this is coming on. We seek payment of 1.3 million in security. I'll show you the breakdown, if I may, of the cost schedule.
Yes.
It's at 5867. And you will see that it is the breakdown of hours comes on the next page. And there are a number of points to make. We make some of them in our skeleton argument, but you will see that the vast majority of the solicitor work is being carried out by 3 people. There are more fee earners who are working on it, but most of the work is done by 3 people. So it's not one of these cases where there's additional solicitors have been layered on and there's a sort of vast machine billing away and leading to lots of duplication. This does not, by the way, incorporate the costs associated with the next phase, which is that we are going to have to produce expert reports and so forth, and deal with all of that, which will no doubt layer on costs. So we're not adjusting the schedule, but there will be significant further costs associated with the expert phase. My learned friend makes no real attempt to engage with these figures. He just says, well, it's all just too much. He does not provide his own schedule, but what he says at paragraph 63 of his skeleton argument is that he estimates his costs will be around half of ours. So as I understand his submission, his evidence, in fact, in his skeleton argument, he's saying that they have incurred or will incur or expect to incur a total of around $875,000. Of course, we have to start from scratch on all of this. And amongst other matters, Kroll is the investigating party that has been engaged in this for years, whereas we're going to have to go and get a new expert who is not involved, somebody who's genuinely independent of all of this. And as I say, costs have been exacerbated by the way in which the case has been developing. So, for example, my learned friend, you will recall at the last hearing, was asserting that some of the assets were ghost facilities. So one has to go away and put evidence together in relation to that. And then that has become, well, actually, those facilities are not worth what they were previously said to be worth.
Yeah, I mean, just in terms of the cost schedule, I'd like your submission on hourly rates, because clearly these are London rates, and the DIFC rates or indicative rates are lower.
I accept that. They're indicative rates.
Yes, that's true.
So what we'd say is that there will be cases of real complexity and value which justify higher rates, and that's always the position, including in London where that's accepted, that they are just indications. And I'm told that these are below the United States rates.
Oh, they certainly are. I'm seeing $2,300 an hour in the US.
Yes, quite. So
Plus,
yeah, well, there we are. And you know, it's now £2,000 an hour at the top end in London, I think. So, you know, this is complex work, it's high value work, it's work that is made difficult, it's multi-jurisdictional, and we would suggest that yes, it's above the guidelines in the practice direction, but that is justifiable by reference to the complexity and value of the work that's involved. So you're not hidebound to follow those. And I'll come back to, I mean, it may be that on assessment, these numbers come down, and I think that's where this goes to. So when at the end of the case, if we assume the claimants fail, what's the court going to do with these numbers? Will they assess these numbers down? The starting point for that, I just draw your attention to the authority, one authority in relation to this, and it's the Danilina and Chernukin case. If Your Excellency could go, please, to page 7458. Actually, I'm going to take you to two authorities, if you don't mind. Very brief on quantification. It's paragraph 57.
Sorry, 7458.
7458, thank you.
Yeah, I have that.
So in determining quantum, there are two passages from this authority that are relevant that I'd like to show you. Paragraph 57, in principle, security should be tailored so as to provide protection against the relevant risk. On the judge's finding, the relevant risk is that of non-enforcement of any cost order obtained. The purpose of ordering security in such circumstances is to secure the defendant against the risk of non-recovery of those costs. Since that is the risk against which the applicant is entitled to protection, I agree with the appellants that the starting point should be that the defendant is entitled to security for the entirety of his costs. And then over the page at paragraph 64, in my judgment, once it has been established that there are substantial obstacles sufficient to create a real risk of non-enforcement, the starting point is that the defendant should have security for the entirety of the costs, and there is no room for discounting the security figure by grading the risk using a sliding scale approach.
I mean, you set against that I've forgotten the precise words, but that rather famous passage in, I think, the Cheshire case, when you look at security, you're looking at somebody who's putting forward a figure, knowing that it's going to be met by somebody else.
Yes, and so I'll come back.
The court has to have a degree of reality of everything.
Of course, but that, and that's right. But actually, there's no there's no sort of universal tariff that is applied to reduce these down, and it's a question of discretion in the circumstances. And so I'm going to show you one more authority, but one of the things I will be saying is there is no evidence before you to suggest that the claimant will have any problem in producing security to this extent. And then there is a sort of balance of convenience.
Yes, it goes back to the old York Motors test.
Yeah. Well, then maybe it's York Motors. I got it from Excalibur Ventures, which is referred to.
I go back further. I'm sorry, I have a longer memory.
Yeah, I was going to say something, but I won't. If we go to page 7499, and paragraph 88, I recommend to Your Excellency, you will know these principles, but the one, I'll just running through them very quickly. The first is that it's broad brush. So it's a robust and broad brush process of quantification. Those are the second to last line in one. In two, it says, in some cases, the court may apply an overall percentage discount to the schedule of costs, dealing with, firstly, the uncertainties of litigation, including the possibility of early settlement, and secondly, the fact that the cost estimate prepared may well include some detailed items which the claimant could later successfully challenge on a detailed assessment. We would say the first element of that is not really going to be significant in this case, because what you're doing is, this is about the quantum, and so the question is it possible that this could all settle before you get to a position where the claimant has to pay a costs order? We would suggest that's somewhat unlikely, because that entails effectively the claimant withdrawing their position. And then the third one I just draw your attention to is the balance of prejudice issue. 4 lines down, the balance usually favours the applicant. an undersecured applicant will be unable to recover the balance of the cost which is unsecured. Whereas if the applicant is not subsequently awarded costs, or if too much security is given, the claimant may suffer only the cost of having put up security, or the excess amount of security, as the case may be. In other words, there may be some cost associated with putting up security. You've got no evidence of that today, and so the balance usually favours the applicant, because if they're undersecured, they're out of their money. If they're oversecured, then it just turns out that the respondent the claimant just gets that money back. Now, in that case, the 2/3 was awarded of the costs that were being applied on a broad brush basis. In our case, we're applying for 75%. But that doesn't, as I say, the figures do not take into account expert evidence and the fact that we now have an increased volume of allegations and therefore a commensurately larger and more extensive return date, 4 days from 2+1. As I say, it's important that the claimant does not say it cannot provide security in that sum. And pointed out there is now also a further return date. So this cost schedule was not put forward anticipating that. So the claimant doesn't say it cannot provide that security. It doesn't actually say it's going to cost it anything to do so. So if you order that amount and the costs are lower, it suffers no loss. But if you order that a lesser amount and the costs are higher, my client will suffer inevitable loss. So that is why we seek the sum that we seek. And if we were to layer in things like expert evidence and the additional costs associated with the developments, then it would be very substantially less than 3/4 of what we anticipate we will end up spending on this. The order that we seek is an unless order. And so you can see that at page, well, the order starts at page 5803, but the substance of it is at 5805. We do ask that it be provided in short order and that there be an unless order attached to it. My learned friend says, well, that's not the usual way, and quotes various passages which suggest that you should take it in stages. And so just order security, and then if it's not provided, leave it to the respondent to make a further application for sanction in relation to that. But of course, and accept that that is the usual way that security is dealt with in the usual case, where you're dealing with a substantive matter that's lining up over a much more prolonged period for trial. But here the problem is things are moving very fast. And so, for example, in the rules, it says if a party doesn't make payment of security, there will generally be no automatic stay. Why not? Because that can slow things down. Here, the rate at which fees are being incurred, the rate at which the return date is likely to come back at some point, presumably in July, means that if we have to wait for a period for them to produce security and then make a further application and then have further rounds of evidence, then it's not going to be practical to get the protection that security is intended to provide. So they've known about this application for weeks. We say that they don't really have a proper response to it, and they should really be providing security very quickly, and it really should be a condition of carrying this forward. Your Honour, those are my submissions, unless you wanted me to address anything specific.
No, that's fine.
Thank you
very much. Mr. Holloway.
Thank you, Your Honour. So I think for my response to that, I'm going in due course to try and focus on the facts and the evidence that's before you. And I would submit at the outset that this shouldn't be treated as a box ticking exercise for the characteristics or the provision of paragraph 25 of the rules. But you've got to look at this in the round and look at what's actually happening here rather than assertion or speculation. And I think just overall, looking at it that way, my client has paid $2 million in. I know I take your observation about the different forms that can be ordered in. They were ordered to pay that. They paid it immediately. there shouldn't be any further restrictions placed on my client's ability to pursue these proceedings. Now, I can see that my learned friend today is telling you you can't look at the merits of the claim, which is exactly the opposite of what he was saying at the last hearing. But there can't be any avoiding the overall context in which we find ourselves today. The 456 million, most of that appears to have gone. That's what Kroll have said. My client faces a long and protracted struggle to get its money back and to get an account of it. And the respondent, the first respondent, as you've heard again this morning, is really taking every possible step to try and avoid giving a full account of where the money is and what happened to the money. I submit that the Kroll report, I've set it out, presents a prima facie case of fraud, and I don't accept for a second that my learned friend was ambushed by that report. Your Honour, you twice in the course of that first return date hearing said that you absolutely assumed that we would be getting Kroll to analyse the disclosure of Mr. Britton. If it was an ambush, it's the worst kept military secret in history. Of course, we had to analyse that material, and so there's that. And we're looking at this as an interlocutory application in support of foreign proceedings. Now, I accept that you cannot, at this point, form a view of who's going to win or lose the case in Hong Kong, but in terms of our burden to present a serious issue to be tried, I would submit you cannot say that we haven't done that. In fact, you've twice already said that we have met that burden, both at the return date at the ex parte stage. Now, from a legal point of view, then, this is not a classic security for costs application because it is not dealing with the merits of the substantive claim in Hong Kong. Those proceedings are still at the preliminary stage, but I would submit you must have realised that we have met the preliminary threshold on the merits that we're required to adduce to get the interlocutory relief, and with very good reasons for ordering that. Now, turning to your Honour's point about fortification, I totally accept that there are two different legal mechanisms by which that sort of security can be ordered, but in reality, they do the same job. The cross undertaking in damages it's phrased in our order as an undertaking to compensate for any loss that the respondent suffers by way of the injunction. That does extend to legal costs, and quite rightly so. I mean, it's obvious that if they were to set aside the whole thing, the costs that they would have incurred in doing so would constitute loss to them, and would be open to them to enforce the undertaking against the cross undertaking on that basis. And that's just that's supported by two authorities that I refer to in my skeleton. The first is the extract from Stephen G, which is at page 7248, and paragraph 1155.
Let me have a look at that. 7248. Yep. Yeah.
So it would be open to the first respondent to enforce the undertaking and damages in the event that they were to set the injunction aside and say, well, we've had to incur all these legal costs in doing so. And the case on that, which is also referred to in the skeleton, is Shattini and Silvestri, and I'll turn that up as well. It's page 7232. Going to paragraph
Sorry, forgive me. 7232.
7232, I believe. I'm going to skip.
7232.
Sorry, the relevant paragraphs are 29 to 32. And what you get is a sort of trot through the case law. And the context of that is someone was trying to apply for fortification in the context that security for cost couldn't be ordered against them because they were a resident in a EU member state or something like that. So it was a kind of, can the undertaking do the same job as a security for costs application? And trotting through the cases, the court there referred at paragraphs 30 and 31 to an Apex case. And they say it's all a question of how the undertaking is phrased. So, for example, if the undertaking was to say damages, you can recover damages under the undertaking, arguably that wouldn't apply to legal costs. But if it was to say loss, like our undertaking does, then it would. And paragraph 32, again, in the Abbey case that they referred to there, they said, well, it would be an affront to justice if you had given such an undertaking and then tried to argue that legal costs were not recoverable under that undertaking. So I think the real point here is that they are two different legal routes, but the substance of them is the same. They're giving security to the first respondent. And really, in reality, what the first respondent is arguing for is a top-up of that security. And, you know, I think that there's a problem with that, because I think what my learned friend's trying to do is avoid the case that he pressed on, Your Honour, at the first return date hearing, which is the Energy Ventures case. And the reason that they're trying to avoid that is because when you're looking at fortification, it requires you to have a look at what the risk is of the undertaking needing to be fortified. And I'll refer back to the relevant paragraph of that. It's at page 7016. It's Lord Justice Tomlinson at paragraph 53 of that case. Sorry, I'll get you the right page for the paragraph number. It is 7038. Hold on. 7032, I believe.
Sorry, 38 or 32?
7032, I believe, sorry.
Okay.
So under that test, which my learned friend made a lot of at the last hearing, you've got to make a proper estimate of the risk. And in that paragraph, it requires the court to ascertain whether there's a sufficient level of risk of loss to require fortification. And I think my learned friend doesn't like that now because he doesn't want you to look at the merits. And I submit that's because we have met the threshold that we're required to meet on the merits to get an interlocutory injunction. You can't conclude that it's likely that that would be set aside. We've shown a serious issue to be tried. It's not a high burden, and we've met it. And so I would submit that those tests overlap legally, and what, you know, ultimately this is a question of discretion. I think Your Honour has to be aware of the security that's already been ordered and why it was ordered and how much more is needed. So the next submission is we've paid 2 million security. We were asked for it and we paid it. But looking at how that was done, Your Honour, in terms of ambushes, there was no application for that. That was all brought in my learned friend's skeleton. And there was, in my submission, very little evidence. There was a lot of sort of submission and assertion of how serious a risk there was. But I'm going to take you through the actual evidence on that, if I may, because I think the court must rely on actual evidence in order to quantify what the risks are. Again, I'll just to set out that position. I want to take you to two authorities again. The first is Omni Bridgeway case, and that's at page 6732. But I want you to look at there's a decision of Mr. Justice Jacobs in the Commercial Court, but I want to take to paragraph 6, which is at 6734. And just towards the end of that paragraph, what the court is looking for is sufficient evidence to allow an intelligent estimate of the quantum of losses, solid, credible evidence of future losses, and it says that it ought ordinarily to be supported by some underlying material and ought not to be speculative. Now, what I'd also refer to G again.
Sorry, forgive me. This is a case on cross undertaking or on security?
On cross undertakings, Your Honour, I accept that. And that point is made again in Stephen G's textbook at page 6786, paragraph 11029. He sets out that three-stage test, and then if you skip over to page 6778, after the test is set out, there's a long discussion.
Sorry, 67. You said 67.
6786, and there's a discussion of this idea of risk and how you
sorry,
estimate.
forgive me. I've fat fingered typing.
No.
That's okay.
And then just the very quick point I just wanted to make is at the end of that, after that test is set out, after those 3 bullet points, it says all 3 items, yes, 1, 2, and 3, and then all 3 items require proof of some risk that will be suffered, and then it says assertion of risk is insufficient. There must be real evidence which objectively establishes that list. Now, I want to put this slightly delicately, but throughout the first return date hearing, Your Honour said you weren't minded to actually consider this question of fortification because it had come in at the last minute and we hadn't had a chance to look at the evidence. But I believe perhaps in light of the sort of dramatic submissions that were made about the impending doom that would be associated with what might happen, you were persuaded to do it. I'm not trying to roll back on that, but I do say you have to look at the whole picture in the round as we see it. And my submission is there was no evidence before you really of any risk. And such evidence that was before you has been contradicted by the evidence that's come in since. So if I can just look at that evidence, if I may, and it all came in Mr. Britton's first affidavit. This is the evidence. There were extensive submissions in skeleton arguments about what the risks were, but I wanted to take to the brief actual evidence that was presented to you and to show you that there really wasn't any support for those allegations at all. So I've got a couple of points. And in looking at Mr. Britton's first affidavit, first one is paragraph 30 at page 1539. He said there was a port agreement and there were monthly lay cans with a port in Australia to deliver 500,000 to 600,000 tonnes of grain annually. That was a risk, but there was no exhibit attached to that, no supporting evidence on that at all. The next one in paragraph 49C, that's page 1544. This is about the securitization process. It would have to be stopped. It was 6 weeks away from completion. We've got really nothing on that at all by way of supporting documentation, as we continually have to point out. Then the next section, paragraph 54 onwards, talks about bitumen orders that were at risk and couldn't be fulfilled. Paragraph 54 said there was $12 million of pre-sold bitumen that needed to be delivered in the next 2 weeks. Paragraph 56 said that the plant would need to be closed, the bitumen plant. Paragraph 58 said there was termination of a port agreement would be at risk, and paragraph 59 and 60 said that Tanzanian mines may have to be abandoned. There were no exhibits to those allegations at all, and no evidence of that, just assertion, exactly the kind of thing that we're cautioned not to accept. And then the second affidavit, Mr. Britton talks again about the grain, paragraph 36, 2296. No evidence of that at all, no exhibit, no supporting evidence at all. So that's what really was there in front of you at the first return date hearing. And then since that, what Kroll have actually seen is that there's no supporting evidence for that, for much of that stuff at all. So, I mean, I could go through it, but in terms of grain, I'll give you the references. They say we've seen no documentation to show anything about the grain inventory. That's part of page 4592.
Where's all this?
Sorry, this is in the Kroll report, and they challenge whether there is the grain inventory that Mr. Britton's talking about. The bitumen, they say 4587. We've not seen any evidence, any other documents in support of bitumen assets, and we don't see anything to determine the financial position of EBS Aria or to ultimately determine the value of recovery of any Aria's investments in the bitumen business. We asked on the 28th of March for disclosure of those bitumen contracts, and we never got any answer to it. The coal mines.
So what's the reference to 28th?
Sorry, yes. It is 6214. I believe it comes at the end of that letter. That was one of the things. 6216, paragraph 3L. 3L, paragraph 3L at page 6216. This was not long after the return date hearing. We asked them what on earth was that about, and we never got any answer to it. The coal mines, there's a long section in Kroll.
So can we just clarify that that's not in fact a request for that documentation as far as I read it? And I'm playing catch up because none of this is in my learning forensic.
Well, I've just referred to paragraph 54 of Mr. Britton's first affidavit, and he said about bitumen contracts being at risk, $12 million, and this request says paragraph 54 of your first affidavit refers to contracts to deliver pre-sold bitumen orders for the value of 12 million. These contracts were not provided. There's no point, it's the same. Paragraph 4, provide any further documentation on that. So I'm sorry, it's pretty clear to me. So, Your Honour, that the security that was ordered and paid was based on evidence-free submission and assertion, and I say, looking at it in the round, there shouldn't be any further security ordered, because the 2 million is more than enough to cover what you have evidence before you of any risk to the first respondent. So the next point I want to make is the point that our funds, we have a proprietary freezing order here, are being used by the first respondent to pay for its legal fees, and we have a proprietary claim over them. That's an important factor to be borne in mind in a discretionary basis in terms of whether you are minded to order any further security against my client or not. And I want to take you through the relevant principles on that again as well. So I'll start with G again, and that's page 6783. The paragraph 2156, 55, the first paragraph, and the first sentence of that, the second sentence of that, the purpose of an injunction granted in aid of a proprietary claim is to stop the defendant expending for its own benefit what may be the claimant's property. And that includes legal fees. No one has the right to use someone else's money to pay for their defence. So before there can be any question, you have to look into the full picture of the first respondent. Can they use any other assets to pay their legal bills? And only if they can show you that there are no other assets available, the court has to make a difficult decision on the basis that both parties may have arguable cases who and how is the money to be spent, and it has to have clear evidence before it of that. So I'll take you to another authority on that, Fitzgerald and Williams, and that's at page 6668. And I'm looking at paragraph G on that page. Sorry, we can look further up, but sorry, it's Lord Bingham's judgment. There are two propositions. The second one is any sums drawn by the claimant for living should, in the first instance, be drawn from other funds and not from funds that the court has ordered to be preserved. And then the second proposition, sorry, and then he says the second bit, I don't understand the legal arguability of stage one, but stage two of the argument is as follows: the defendant should not be entitled to draw on a fund which may belong to the plaintiff until he shows there's no fund of his own on which he can draw. Where he shows that he's no funds of his own on which he can draw, the court must make a difficult decision, and then there are the factors that they have to weigh up after that. So we've not got to stage two.
Sorry, this is not the finding, is it? This is he's reciting the argument, isn't he?
No, he's accepting that the argument.
Stage two of the argument follows: defendants should not be entitled.
Well, I mean, you know, the first point is the one that he says is not arguable at all. I mean, it's only the second one.
The judge was, I think, wrong not to accept both limbs. Okay.
Yes.
All right.
So then the next thing I'd like Your Honour to look at are two letters. The first one was the 28th of March, when we've just looked at it. We asked for the evidence, some of the evidence that was before Your Honour at the return date hearing, and we didn't get any reply to that. The second letter I want Your Honour to look at is at page 6309, which is a letter we sent last week, and that in that letter we asked the respondent to set out whether they were able to pay their legal bills from other funds, including from Mr. Britton's funds, and if so, could we see where the assets are? And no answer to that letter either. So the point of this is the one that I've made in the skeleton, that the reality of the situation is the first respondent is using the claimant's money to pay exorbitant legal fees for its own defence. And we've already put more than enough security to cover that in. But if we're ordered to order more, the effect of it is we really have to pay 3 sets of legal fees here. One, our own legal fees. 2, the monies that are being used that are arguably ours to fund the first responders defence, and 3rd, a security to be added. So it's plainly a factor to weigh in your discretion that this is a proprietary order. The next point I'd make is that despite what Mr. Montague-Smith says, the respondent is not in compliance with the proprietary freezing order. They're still delaying giving plainly available documents and information in relation to the onward dealings of the funds. They were ordered to do that in days. We are months later, and despite what he said, I submit there's no reason whatsoever to suggest that they have complied with that provision fully. This is a proprietary freezing order. One of the purposes of it is to enable us to trace our assets, and they are thwarting that with redacted documents, incomplete bank statements, etc. So that we've had my submissions on that earlier. The next point I'd like to make is lateness and delay, and it's a very simple point actually. My learned friend says, well, they made it very quickly after they wrote to us with sort of forensic questions about the operation of our business, and we didn't reply. The real lateness comes in the fact that we've already had a return date, and they're perfectly able to ask for fortification at that point, which is nearly 2 months ago, and there's no reason given why they didn't do it at that point in time. So that's the lateness. They either forgot about it or have decided to do this tactically later, at the point where we're deeply engaged in the case and have actually expended a lot of our own funds in pursuing it. Referring to a couple of authorities on that. The first one is DIFC court practice, which my learned friend will be very familiar with. Page 7247. I think it's really just the first point is obviously as any claim proceeds, the costs already committed by the claimant increase. And that's one of the points here. They should have made this application earlier if they wanted to. And then just to follow up on that through a little bit, the case we've cited in our skeleton, I'm going to call it Re Bennett because it's easier to pronounce than the other name, but it's at page 7213. Paragraph 28 there, this is a judgment of Richard Millett, sitting as a Deputy High Court judge. But delay is one of the circumstances, etc. I think we all know this. But then it explains...
Sorry, which paragraph? Sorry, remind me which paragraph.
Paragraph 28, Your Honour, sorry.
Thank you very much.
It is one of the circumstances in discretion. The court may refuse to order security where delay has deprived time to collect security. That's not the case here. Or led the claimant to act to his detriment. And the court may deprive a tardy applicant of security for some or all of its past costs or restrict the security to future costs. Now, the detriment here is important because, as the other cases show, the point of security is to give a claimant a choice to continue or not. And once they've gone very, very far down the road, obviously that choice becomes less meaningful. So that's why the sanction for that is to either refuse the application or to limit it to future costs or reduce it. Now, this application was made months after it could have been, and Your Honour will remember it was made just try and squeeze it in just before the return date, which had also been listed for months, in order that the respondent could try to somehow put the squeeze on the claimant. It was made right at the door of what was meant to be the substantive return date hearing. So I submit that's perfectly worthy of the sanction of either refusing it or limiting it to future costs. Then I'm going to talk about the unless order aspect of the application. And I don't really need to say too much about this, but there's absolutely no reason whatsoever for any order that you make to come with any sanction on the claimant. The claimant has complied with every direction made, to the best of my knowledge, and made applications properly. It is simply not appropriate for any sanction to be levied on the claimant, and I'm not sure, on what basis that is. I mean, my learned friend said, well, it's because it's all moving very fast. I'm just really not sure that that's any basis on, this is our injunction, Your Honour. We're making the claim. We applied for the injunction. The idea that we're going to try and delay things by not paying security is farcical. And look at what's actually happened. The first return date was adjourned because my learned friend didn't have enough time to prepare his evidence. And the second was adjourned because he apparently needed to put expert evidence in order to show whether there's an arguable case of fraud or not. There's no basis whatsoever for any sanction, and the authorities are pretty clear on that. Then returning to quantum, so I mean our primary submission is no order should be made. Looking at the evidence in the round, there's no evidence to suggest that the 2 million is not enough that they have. If you're against us on that, it should certainly be reduced to future costs or substantially. And then when we look at quantum, frankly, Your Honour, I think you've already seen the points that I'm going to make. But looking at page 5867. Just looking at the fees, I mean, Your Honour's already picked it up, but the partner rates are 50% higher than the recommended DIFC rates. The associate rates, I mean, Mr. Brynick, a 2-year qualified associate is being charged at $1,000 per hour. I mean, that beggars belief in terms of us having to meet that bill. This is DIFC litigation. It is not US litigation. So I'll say no more on that. Yeah. So if you're against us on the evidence, you're against us on the principle. The security should be reduced, maybe ideally to future costs, if not a substantially reduced figure based on those hourly rates. And I submit that those hourly rates indicate the problem that I highlighted earlier, that our money is being wasted here, and we cannot escape the fact my learned friend tried to resist it last time. It remains a proprietary freezing order, and it's not appropriate for the sums to be expended in that way without proper control or some reason as to why those funds need to be spent in that manner. So that's all I'll say, Your Honour. Thank you.
Thank you very much. Mr. Montague-Smith.
Briefly in reply, if I may, Your Honour. Firstly, my learned friend opened by saying that Once ordered to pay fortification, his client had paid immediately. That's factually false. In fact, his client didn't pay at all. He needed another party to pay and also needed an extension of time to pay. So that's just inaccurate. My learned friend complains about my saying today that you should not be looking at the merits when considering security. He says that's inconsistent with the position I took at the last hearing. That's because two different tests apply. Sorry, my learned friend, could I just ask you, Mr. Holloway, to turn his microphone off? Sorry.
Oh, I do apologise. I'm sorry.
Not at all. The reason I asked Your Honour to look, at least to some extent, at the merits of the last hearing was because we were dealing there with effectively the American cyanamide test, and one had to balance the potential harm against the strength of the case. That is not part of the test today, and the rules are very clear. Unless you are clear what the outcome is going to be, then you cannot take it into account. There did seem to be some suggestion in my learned friend's submissions that an order might stifle the claim. It wasn't put quite in those terms, but if that is the submission, that's never been raised before. There's no evidence to support it, and it is totally incredible because Techteryx has pursued widespread litigation in multiple jurisdictions, including the Hong Kong proceedings, the application in Cayman, made on the basis that Techteryx was a shareholder in the fund, a statutory demand that's been presented in Cayman prompting injunction proceedings to prevent the presentation of the statutory demand in Cayman, and so leading up to a proliferation of litigation in relation to that, and then also the receivership application against the fund in Hong Kong. So the idea that they can't come up with $1.3 million, if that is the suggestion, it is not a credible submission. Then my learned friend focused in on fortification, and he suggests, well, that fortification can be used to dip into for the costs. But that is not the basis on which the fortification was quantified. I'll just remind Your Honour of the position, which is the order was at the decision was at page 1101 of the bundle, and what you said was, Aria Dmcc seeks a relatively moderate fortification in the context of the sums at stake in these proceedings, and appears to me have genuinely sought to place a figure on the cost of disruption to its business on its case between the date of this order and the return date. I accept that fortification in the sum of $2 million should be provided. So that's what that quantification was for, disruption of business. It had no reference to costs. And as to whether or not we could dip into that in relation to costs, Your Excellency was taken to page 6734, which was the Omni Bridgeway case, and paragraph 6 of that. And the bit that wasn't read to you was the bit that says it is only loss which is caused or would have been caused by the preventative. Sorry, 6734. 3 lines down at the end of the line. It is only loss which is caused or would have been caused by the preventative or coercive effect of the injunction that is recoverable under the cross undertaking. That's the position that's been accepted in the DIFC courts. So it's only the coercive effect of the order to which the fortification responds. My learned friend says, well, actually, you can get your costs, and relies on some English cases with rather extreme facts, we would suggest. But 2 points arise. One, that doesn't appear to be the way that it's approached in the DIFC courts. And secondly, that is not the way that fortification was assessed by Your Honour earlier on in this case.
Which DIFC authorities are you referring to?
This is the DIFC authority of Omni Bridgeway, which we're looking at here at page, it starts at page 6732. And my reading of that passage is that is what was being accepted.
Oh, I see what you mean. I'm so sorry. Yeah.
So the first question is, could we get our costs out of the fortification? And we would say that's doubtful.
That's an English case, I think.
No, this is Omni Bridgeway 6734, citing with approval. And my own friend will no doubt have submissions to make in due course. And all
so I'm just sorry. Let me just go back to page 6732. So Omni Bridgeway is an English case.
Oh, you're absolutely right. I'm so sorry. I thought there was
That's
only
why I'm
which
sorry.
way
That's why I was getting. That's
cases.
why I was
No,
getting.
you're absolutely right. I withdraw that, and I apologise to my little friend. He made the right intervention, and I'm so sorry. So um, my point was that it's doubtful generally whether or not a fortification of a cross undertaking would meet a costs order at the end of a case. And but the more substantive point is that Your Honour has assessed that fortification on the basis
that point that I've got.
of the
That
loss.
point I've got.
Yes,
Yeah. Okay.
thank you. But then what my
But
learned
you're not
friend
suggesting
did,
there's a different practice
in the DISC to England.
no, sorry, I misunderstood that particular
Okay.
passage, and I apologise.
No.
What my learned friend then does is he goes on to say, well, fortification, the basis on which you made the decision previously was wrongly decided. But the point there is that there was an application for fortification. Your Honour decided it, and it's never been challenged. It's not simply not open to my learned friend to say $2 million is far more than my client would suffer as loss as a result of this order if it stays in place until July and is then discharged, or whenever it will be. It was expected to be today, but it's going back. So we're not seeking to increase it as we might do. But in any event, we do say this: the general overall submission is simply unreal, which is that in effect my learned friend's saying there's just no prospect of my client DMCC suffering any loss as a result of a $456 million freezing order. And we'll come on in the attachment application to see how that's actually been implemented onshore, but ultimately the evidence is that it's prevented payments in and out for both the DMCC and for its subsidiary Aria Bio. But you don't get into any of that debate, because that was my submission I made previously, which we sort of ran over, and Your Honour said, well, it's apples and oranges. Even if it's apples and apples, the point is that my learned friend is basically saying now you need impliedly to vary the order that Your Honour has made previously to allocate some of that $2 million to costs. And that's an implied variation of the order that you've already made. And the order, the submissions that are made in relation to legal fees are essentially the same. So my learned friend said, well, the funds that are being used by the first respondent are to pay legal fees are the claimant's own funds. It's their money. They have a proprietary claim to it. And that is a factor, he said, to take into account in the security application. And he said he would make that good by reference to authority. But the authority that he took you to was authority about whether or not there should be exception to permit payment out of funds in a proprietary case in respect of legal fees. So the passages in G, for example, at page 6783, he took you to the passage at 21055, which is about effectively whether there should be an exception permitting payment of legal fees out of sums that are subject to a proprietary injunction. That's 21055. And again, the same in relation to the case at 6668, which is the Fitzgerald and Williams case, and the one that you questioned, my learned friend, about whether or not these were submissions or whether they were conclusions. But the point is that it said a defendant should not be entitled to draw on the fund and so forth. Now, there are exceptions to those situations, and it is perfectly acceptable for the court to make an order permitting drawdown to use for legal fees in a proprietary case. And again, this was the subject of argument at the last hearing, and the order was maintained. So effectively what my learned friend is saying is, well, you should revisit that decision again and decide to vary it, and that is not open to him. Beyond that, the question is just, well, how otherwise is it then relevant to the assessment of whether to order security? The point about security is you don't take a view on the merits, and you think, well, at the end of the case, what happens if the claimant loses? At the end of the case, if the claimant loses, all of this falls away. All of these arguments that that's my money and all the rest of it just falls away, and that we're left with a giant legal bill which the claimant is obliged to meet. On timing, my learned friend said we should have done this at the first return date. That is, with respect, totally unreal. Anyone who's done any number of these sorts of applications knows that the first return date is very, very rarely effective in a meaningful sense. The reason we had to make it effective was because we needed that variation to allow business use, which Your Honour granted. My learned friend then took you to an authority on delay, which was the authority at 7213, paragraph 28. And he said, delay in making the application is one of the circumstances to which the court will have regard when exercising its discretion to order security. The court may refuse to order security where delay has deprived the claimant of the time to collect the security or led the claimant to act to his detriment or may cause hardship in the future costs of the action. So there's two parts to this issue. One is, has there been a delay? And we don't accept there has been a delay. And the second part is, well, if there has been delay, what impact has that had? My learned friend accepts that it hasn't caused them any harm in terms of depriving them of the opportunity to collect the security. But he says, well, you know, the longer you leave it, the more difficult the decision is whether to pay the security or not proceed. So what he's suggesting, it appears, is that had there been a security order, security for costs order made at an earlier stage, then the claimant might have pulled out and said, well, I'm not going to actually bother with all of this because it's now getting too expensive. Two answers to that. One is there's absolutely no evidence before the court that that is a real factor. And it's very unclear whether my learned friend's actually saying it is a real factor. Two, if it is a real factor, it should cause real alarm to this court that an additional $1.3 million worth of costs might cause the claimant to actually walk away from these proceedings. And that is all the more reason to order it to make security, to give security, because the chances of actually seeing that money at the end of the day, if this all falls apart, as we say it will, is even more unlikely. And then finally, in relation to sanction, I've made my submissions in relation to sanction. It is the speed with which this is moving and the practicality of actually bringing back an application before Your Honour for a sanction if they don't comply. My learned friend's submission was potentially quite carefully crafted. He said they've complied so far with everything they've been obliged to comply with, albeit late in relation to fortification, we would add. What my learned friend did not say is if you order them to pay security, they will make that payment. I believe those were all.
I have a question for Mr. Holloway, which probably now is a good time to ask it, so that Mr. Montague-Smith, you can address it if you feel so inclined. Mr. Holloway, if I were to order security, when would the claimant pay it? In other words, how long would it need to meet an order for security?
I think we've said between 1 and 2 weeks in correspondence, and just to correct the record, we did pay the fortification on time. We did apply for an extension of time. We didn't need it apart from $15 in exchange rate fees that we needed.
Okay.
So right, please.
But you would ask, if I were minded to make an order in any sum, you would ask for 14 days.
Yes.
Yes. Okay. Thank you very much. That's helpful.
So if we look forward down the timetable for 14 days, if it's paid, all well and good. But the problem arises if it's not paid, we are already then at the 26th of May. Now we need to come on and talk about when ultimately a hearing will take place. But our working assumption is that we're looking at a hearing in July. They've known about this application for some time, and the question then becomes, is it realistic to consider that Your Excellency and the parties would be able to come together for an application to deal with sanction at some point between the 26th of May and whenever the hearing is, in time to actually make any kind of sense? But I won't repeat those submissions. That's all I have to say.
Well, thank you very much indeed. Okay, we're doing pretty well on time, but let's. I'm just a bit conscious, obviously, that in Dubai it's lunchtime, uh, or we've sat over lunchtime. Just can I ask, on your side, Mr. Holloway, if we just took 10 minutes now, would that be a problem, or would you and your team like a bit longer?
If we could have a little bit longer, I think we could try and grab a snack, but not much
Okay, yeah,
longer.
I don't want to put you on too much pressure. So we say 20 minutes, come back at 20 to 3, then that will give us enough time to finish well within the time order. Okay, so we'll take 20 minutes now and come back at 20 to 3 or 20 to 12 UK. I think I got it right this
That's
time.
right.
Okay, thank you very much indeed.
Good. Okay, you managed to get your team a snack?
I got
Mr.
my
Holloway?
snack, and I think they
You
helped
got your
themselves. I hope so.
Okay, good. So, Mr. Montague-Smith, application number 8, I think.
Yes, thank you, Your Honour.
Okay.
Sorry, you were going to say something.
No, it's 8, isn't it? Is it 9 or is it 9?
Is
It's
this
number
10? Sorry, I should know. In fact, I've got the.
It's the withdrawal. It's
application.
the withdrawal. It's the withdrawal
It's the withdrawal. It is 9. You're
of the
absolutely right.
attachments. Yes, it's 9.
Yeah, the page is 5871. That's right.
Yeah.
So yeah, it's an application for an order requiring the withdrawal of the attachments in relation to the bank accounts on shore.
Yes.
And this should not take too long. If you've had an opportunity to read the skeleton argument, if you've managed to read the primary evidence.
I have, but I have to say, I find actually of all the applications, I think I found this the most complicated. But there we go.
Well, let me give you a snapshot of what we say, and we can go through it in detail if we need to. But essentially, what we say is that Your Honour made the order, subsequently varied it to allow permission for business use. So that's the effect that this court has said should be the result. But what has happened is that the way that the order is operating onshore, having been enforced through the onshore courts, is to prevent that from happening. So essentially, what has happened is that the result has been that in relation to each of the bank accounts, every single one of them has been subject to a debit of equivalent to 450 million US dollars. So in sum, you can see the available balance is X, but the actual balance is X, but then the available balance is X minus $450 million.
Forgive me, because I've not looked at the exhibits. Do I have those bank accounts?
You've got the statements yes, you've got the statement of what's available in each one. So you do. You don't have a sort of full tranche of bank accounts, but I'll take you to
Yes,
them.
if you would. I haven't seen those.
But I'll show you them now if you like, just so that you've got them in your mind. Leave 6071 should be the page. Yeah. So 6071.
Okay.
So this is the ADIB accounts. And what you can see is you don't see a statement of what's actually in them, but you can infer that from the balances because you've got dirhams, saving account, and then the current account, and they're both broadly the equivalent to the full sum that's been deducted, which is 1.67 billion dirhams, which is the equivalent in dirhams.
So there was nothing in 3 of the accounts.
Exactly. Very limited amount perhaps in the second one, but the two central ones are the US dollar account of minus 449 million and the euro account of 392 million. And essentially you can infer from that when one deducts the 455 million that pre-deduction account number 3 on that page would have had about $6 million in it. And account number 6, sorry, would have had about 13 million euros in it.
30.
13.
13.
If you go over the page, it's simpler in relation to the Mashrek accounts. Those are at page 6072. And you can see that those have much smaller balances.
Yes.
So there you can take, for example, the euros that are the equivalent of deduction, which has been applied across the board, 434 million euros. So a zero balance becomes minus 434 million euros.
Yes, and they only had pretty small sums in them anyway. So 19,000 and 2,500.
Yeah, sorry, and I might be misunderstanding the precise difference as to the balance of that account. I can check that for you, but if one goes back to the ADIB account, you can see the euro account is minus 392.5, but the Mashrek account is from a standing start at 0 is minus 434. So I may have misunderstood. It may be more like 30 or 40 million dollars, but actually I'm going to ask for some instructions in relation to that. In any event,
yes.
There's some substantial sums which are to the credit in the ADIB accounts, which we cannot use because the available balance is in negative. And I'll just check if whether we've got in the
I think 13 million on the ADIB account and the euro account is probably an underestimate.
Yes, correct. You're probably right. It looks like if one just assumes that the conversion was done on the same date between these two schedules, that it's 34 plus about 7.5. So it's 42 million.
Yeah, so around 40. Around 14 billion.
That's doing the best I can. I can
do the arithmetic myself.
Thank you. Very good. All right. So the essential point that we make on this application is to say, if the result that is to be achieved is that we should be entitled to use these accounts for business use, then, and that has been decided and no challenge is made to that order, then we the parties together need to be taking steps to resolve the problem that has arisen. And at the moment, the only resolution that appears possible is withdrawal of the attachments entirely. The response from the claimants appears to be twofold. I'll deal with it in order, but in due course. But firstly, they effectively say, well, we've done what we were obliged to do. The consequences are the consequences. If you've got a problem with them, off you go to the Dubai courts. I would summarize that as saying that's your problem, not our problem. That, we say, is not a principled response. If the result of the attachments is that they go beyond the proper effect of the order, then they should be withdrawn. And that is what happened in the SCAT case. And I'll take you to that in due course. The other point that my learned friend makes is he says, oh, well, look, there's hardly anything in them anyway. So why do you need them? And the whole thing must be tactical. But we can see that there is substantial amounts. There are substantial amounts in those accounts. And clearly, in a way, he's arguing against himself, because the less there are in those accounts, the less possible harm there is to his client in allowing us to use those accounts, and the more harm to my client in being unable to use what is a trading fund. The evidence in relation to this is really starts, if I can take you to page 5881. And paragraph 13. And really, so what this is Mr. Britton's fifth affidavit. Yeah, so sorry, in terms of the balances on the accounts, my client isn't the instructions are we don't know precisely what's in those accounts, and had an up-to-date statement in relation to those ADIB ones. So the point is made that each of the banks was directed to deduct the full $456 million. That's the full amount that went out that came into DMCC. So it takes no account of the distribution that was made, but more importantly, every single account has just been said minus 456 million. And if we go down to paragraph 15 on the next page, you can see what happened next, which is that firstly, paragraph 14, Quinn Emanuel wrote to Al-Tamimi making this point and saying that these attachments and the way they've been implemented was inconsistent with Your Honour's order varying the terms to allow for the ordinary course of business. And the response came back on the 3rd of April that Techteryx had notified the onshore courts of the variation. So it was said, well, on the 3rd of April, that's what had happened. And I'll come back to precisely what the chronology was behind the scenes at Tamimi, and maybe my learned friend can shed some light on that, because it remains slightly opaque about precisely what happened and what the chronology was on the Al-Tamimi side. But the result is that over the page 5883, paragraph 20, it was not until the 24th of April that we received copies of letters issued by the onshore Dubai courts to the banks. Those appear to have been issued on the 22nd of April, so 2 days previously. And they were addressed to the respondent banks. And you can see the terms of the variation that was issued by the onshore courts. They simply said, Dubai Execution Court decided to contact the respondent banks in order to continue applying the freezing order on Aria DMCC's accounts in accordance with the original judicial order, with implementation of the amended order issued on the 18th of March. It's a bit unclear quite how that would have been received by the banks, but in any event, the variation appears not to have arrived at the banks until a full month and a bit after it was issued by this court. Now, Mr. Britton then goes on to explain what has been the effect on the accounts. And you see that at paragraph 22 and going forwards. And he refers to the Aria DMCC accounts with both Adib and Mashrek. And he explains, if we go down to 58, and I've shown you the particular accounts, and if we go down to page 5884, paragraph 23b, so I think I took you this morning to paragraph 23a, which explained a little bit about why there were other accounts listed. 23b, the DMCC Adib accounts are one, some of the primary bank accounts used by Aria DMCC to pay expenses in the ordinary course of business, and two, the bank accounts with the largest sums, and makes a point in response to something that Ms. Jabala had made in her said in her witness statement, which was that some of the balances seem to have changed since the order was made, but of course that was the result of being entitled to use them for the ordinary course of business, as he explains. So then if we go down to D, you see he says, as noted above, the practical effect of such negative balances is that Aria DMCC has been prevented from remitting payments from the DMCC Adib accounts and the DMCC Mashrek bank accounts in the ordinary course of business. And he exhibits some examples of invoices which Aria DMCC is simply unable to pay, and then makes the point that at E, Adib and Mashrek have ceased to process inward remittances into those accounts, which means that counterparties can't actually bring the money in. So it's having an impact in both directions. The attachment is also affecting the subsidiary, Aria Bio FZE. So one of the side effects of the order appears to have been suspension of trading on the Aria Bio accounts as well. And Mr. Britton gives evidence of that at paragraph 24. Now, at the time that this statement was written, the position was that Aria was also prevented from making payments both in and out, or receiving payments in and making payments out, As I understand the position, that is now changed, and FZE can now receive payments, but it is still unable to make payments. So
sorry, you said FZ, so Aria Bio can
Aria
receive.
Bio FZE is what, yeah, he refers it to as FZE. So the position as it stands is that Aria DMCC cannot receive or issue any payments at all on its accounts. Aria Bio is prevented from issuing payments, but is now, after a pause, able to receive payments. There is paragraph 27. Mr. Britton identifies what has been the workaround to date, which is, he says, in effect, that a temporary solution has been, where possible, for other Aria group entities to try to make or receive payments on behalf of Aria DMCC and Aria Bio. And he refers to payments coming in via, for example, Aria AAAX, which is the Australian entity within the group. But he says that's not practicable for every payment. And obviously, in a sense, what that is doing is it is bypassing Your Honour's order altogether, because we're having to route payments through other entities. So it's almost worse for the claimant that's happening, because they will have no visibility of that. But the disruption, we would say, is considerable, and there is supporting documentation to support that. So if one goes down to page 6075, for example, you can see an email there from Shell chasing payment of a balance that's overdue for $343,000 and asking for payment at the end of the month. And then if you go back up the chain, you can see that there's subsequent further chases for payment of those sums. So there's a substantial amount in relation to that. And the question from my client's perspective is, what should they tell Shell about this? We can't make the payment because we're subject to a freezing order. They ought to be able to make the payment.
What company is the debtor?
I'm not sure. I think that is it looks like that is about an Aria Bio debtor, but being paid through a DMCC account, but I'm not sure. And I'll check in case we've got information about that. But there are, if one goes down the bundle, yeah, that's an Aria Bio, I'm told, sum that's due to be paid. If one goes down the bundle, so for example, to page 6078, you've got another invoice for the sum of just shy of $300,000 in relation to Aria Bio. But then if you go down, there's another few in relation to Aria Bio, and then down all the way to 6082, you will see Aria DMCC invoices.
Sorry, 6082.
Yes. So the ones before that are bio invoices, 6082. There's a tax invoice at 6084 from Argus Media, and then 6085. There's another invoice, 6086. There's another invoice, all of which needs to be paid. But we would say that once you can see that the effect of Your Honour's order is that the accounts are essentially debited, and if you accept that the result of that is that we cannot use the accounts, DMC simply cannot use the accounts, and the practical effect of the order is that in practice, the amendment that you made for business use, it is not being carried through. And the question then is, well, what, if anything, does Your Honour do about it? Do you just ignore it and pretend it's not happening? Or as we would suggest, having decided that it is right that Aria DMCC ought to be able to use its accounts for business, and that Aria Bio, by the way, ought to be able to use their accounts for business, if the effect of the attachment is that that is being stopped, then if there's no other solution, then the only solution must be withdrawal of those those attachments. Before we come on to that, and I'll show you a case in relation to that, but before we do, there is some doubt about the timing with which the claimant actually notified the court of the variation of Your Honour's original order. We don't know whether if they'd done it sooner, it would have made a difference, whether it would have nipped things in the bud, but then it cannot be impossible. If we turn, please, to just show you the evidence in relation to this, 5995. So this is Ms. Jabala's third witness statement, I believe. And she refers to the inter partes correspondence and refers to that correspondence that Mr. Britton mentioned, and I showed you the passages in his statement that dealt with it. So 6.1 is about Queen Emmanuel's letter saying what had happened, that the attachments had prevented, well, that's the letter. She doesn't describe it in those terms, but that's the letter where they say, this is the effect the attachments are having, please withdraw them. And then in response, you'll see 6.2, on the 3rd of April 2025, Al-Tamimi wrote to Queen Emmanuel confirming that a request had been filed with the Dubai courts, notifying it of the variation order. We don't know when that request was first done, because what appears to have happened is that the Dubai courts appear to have come back and said you have to go through the execution mechanism, or that the request to lodge the variation of the Dubai court's order has arisen, needs to be dealt with in a different way. So, for example, if you go to page 6008, you'll see an application issued by the claimant on the 4th of April. So this is after it was said that the variation request had been sent to the Dubai courts. And then on the 4th of April, the day after that, and so what are we talking, 2.5 weeks after the variation was issued, that's an application to enforce, as I understand it, the variation of Your Excellency's variation order. So one way or another, the process for effectively giving effect in the local courts to your variation made in mid-March was not started until the 4th of April. Now, something may have happened before that, but it's very unclear what. If we go to 5996, so back to Ms. Jabala's witness statement. She talks about an explanation that was given at the top there, paragraph 6.4.2. She refers to a further request to the Dubai courts on the 4th of April, stating that the variation order permitted the first respondent to transact in the ordinary course of business, and therefore requesting the court to issue directions permitting the first respondent to withdraw the funds for business purposes. And then talks about filing a further application with the Dubai courts on the WEAC system, enclosing copies of the sealed variation orders. And it looks like, yeah, so sorry, the bit that I wanted to show you was the previous subparagraph at 6.4.1 on page 5995, where it looks like what she's saying is that that Part 45 application that I've shown Your Honour was issued because that, she says, as directed by the Dubai courts in its decision dated 3 April 2025, announced on the Dubai Courts portal on the 4th of April 2025. So there's a couple of points here. First, we don't understand why the claimant didn't do it that way in the first place, why they had to be told by the Dubai court that that was what they needed to do. And second, we don't know, as I understand it, when the application was first made, which prompted that indication from the Dubai courts. Don't see that in the evidence. It may be that this wouldn't have made any difference and we would have just been in the same position but earlier. But it's hard to say whether, if the claimant had acted more quickly, the problem could have been nipped in the bud, because the original attachments based on your Honour's original ex parte order only landed shortly after the first return date hearing. So it's hard to know whether or not further action could have been brought to, in effect, sort of intervene or catch that attachment order before it actually went out in the first place. And one can see, once the attachment order goes out, subsequently saying, well, it continues, but with a variation, you know, if it could have, it's hard to know whether it could have been crafted differently. But actually, more importantly, is regardless of how this all came about, and we do say, you know, it's incumbent on a party in the claimant's position to move as quickly as possible. But even if they have done so, even if they've done everything that they can, the result is that the variation has had no practical effect on the attachments. And I've shown you the documents which demonstrate that. But Mr. Britton's evidence supports that, 6038, and he explains that in paragraphs 14 and 15, and he gives an update in relation to it. And then I've shown you the balances on the accounts. So the result is that Your Honour's ordered variation has not been implemented. Whether that's the claimant's fault or not is not the issue. That's just the practical consequence of it. And these sorts of issues do arise in this court because of the way that local courts deal with execution orders. But we would suggest that this is something of a special case, in that this is not an individual who's moved to Dubai and has very, very large sums of wealth, and somebody comes along and says, well, all that money, you're wealthy because you stole it from us. This is a trading enterprise. But in any event, even where you have that situation, like the SCAP case, the solution has been to ultimately just to lift the attachments if they go beyond the effect of what the order should properly be. So we do say it's wrong in principle for my learned friends' clients to say, well, we've done what we can, you just have to live with it, because this court has already considered, after argument, whether or not the first respondent should be entitled to use money in the ordinary course of business. There's been no application to vary that, no attempt to discharge that variation order. And so that's the fixed point around which everything else has to turn in my submission. And if the result is not being achieved, then the attachment has to give way, because Your Honour has decided what is appropriate. The SCAT case, I can just show you that very briefly. It's 7368. And this is the one has always to put place in context the SCAT case. No, it's not. 7363. So sorry. Afraid my eyes are not what they were. Threes look like eights these days to me. So the SCAT case was a very extreme case where essentially $2 billion of the Denmark's money had gone missing in what the Dubai courts have now found to be a fraud, for which one of the main respondents, Mr. Shah, was primarily responsible. So Mr. Shah is now in prison in Denmark for this. So that was one of those cases where, Mr. Shah was sitting on a lot of wealth in Dubai, and he ultimately was stolen money from the Danish state. But even in that case, if we go down to paragraph in the reasons on page 7364, paragraph 3. So Jeremy Cook says this: because the relevant accounts are in onshore Dubai, the order was subject to recognition by the onshore Dubai courts in the form of a recognition order, which took effect as an attachment order dated 10 September 2018. The nature of such an order does not allow for an exception of the kind which appears in paragraph 10.2 of this court's order, which means that those accounts are absolutely frozen. If the money is in them is to be used for the payment of ordinary business expenses, the attachment order made in the onshore courts must be discharged, at least pro tanto, in order to make the payments. So essentially what he's saying is, just as a matter of principle, if it's right that they should be entitled to use that money in that way, and the attachment is preventing that, then the attachment has to give way. And he says that again at paragraph 13. And what he says is the order should provide for a joint application to be made to the onshore Dubai courts for the discharge of the attachment order. So on the principled objection, we say that regardless of how this came about and whose fault it is, if that is the outcome, that is what needs to happen. If it's right that Aria Bio and Aria DMCC ought to be entitled to use their accounts for business purposes, then that must be what this court makes orders to facilitate. As I say, my learned friend has a second point, which he raised.
Can I just ask you,
Yes,
I know that you're very familiar with the facts of the SCAT case. Was that a proprietary injunction, the SCAT case?
Yes. Yes, because the allegation was that what had happened was there were applications to recover tax, which was alleged to withholding tax, which was alleged to have been withheld in relation to shares, and so inducements were made to say, I held those shares at certain times, so give me the withholding tax, when the claim was they did not have those shares and therefore did not have that entitlement to claim the withholding tax. So money came out of the Danish state. But the point doesn't arise in our case because it's a principal point. It's not about the question of whether or not it's proprietary, and it was a proprietary claim in that case. It's about whether or not it's subject to an exception.
Well, the only reason I asked that question is, I mean, ultimately, it seems to me to be a matter of discretion, and an element in that discretion would be whether or not it's a proprietary injunction or, if I call it, an ordinary worldwide freezing injunction. I can see there could be differences of principle. I'm not saying there are, but it just playing across my mind.
I think no, sorry, and I'm actually corrected. Paragraph 2. So I don't want to mislead you on this. Paragraph 2 makes clear that actually these are accounts which are not subject to the proprietary. So the claim was a proprietary claim, and it appears that effectively where monies could be traced into accounts, those were not the accounts that were being dealt with on this application.
Okay.
But the reason why I say it doesn't make a difference is because ultimately the question was not, is this proprietary or is this not? The question was, is this subject to the exception? So if you look at paragraph 2, what's said is the accounts which are held.
Yes, sorry. No, I see that. I see that, but it's just playing across my mind that it may be argued there is a difference where the balance lies in terms of uh, who suffers.
Well, I understand.
Whether, yes,
I
I mean,
understand the
whether,
point.
yes, yeah, well, quite, I don't have to make it.
So the answer to the point is that all those sorts of arguments go to the question of whether there should be a business use exception at all. Because once you have that business use exception, the court has decided that regardless of the nature of the claim, these sums can be used for those purposes. That's the full extent of that's the proper extent of the order that's been made. So the reason why it was relevant in this case, SCAT, that these particular accounts were not proprietary account, no claim was made that was proprietary, was because is set out in the third sentence of paragraph 2. The sums therefore are subject to paragraph 10.2 of the order, which provides there is no prohibition on the two defendants dealing with or disposing of any of their assets in the ordinary and proper course of business.
So actually in SCAT, there wasn't an exception for ordinary course of business in relation to proprietary. It was only in relation to the non-proprietary. Yes, that's what I derived from that. Yes.
Yeah. I think that must be right. I apologise. I didn't mean to mislead you in relation to that.
No.
This was,
Sure,
but that is an argument that we had at the return date, and to attack that, my learned friend needs to make an application to dislodge the variation. He doesn't do that. What he says is, well, you've got your variation, so you're entitled to use it for business use. But the fact that we've taken steps which mean you can't is neither here nor there. And that's what I'm saying is unprincipled, because it is the fact that we had that SCAT had the benefit of that exception in that claim, which justified.
Can I just try and identify where the problem lies? Are you saying that the problem lies at the level of the Dubai courts or the interpretation by the banks of the Dubai court's order?
We don't know. I don't know is the answer. But we don't say that is a relevant distinction, because if that is how attachments
well, it does seem to me to be
affected,
relevant, because if the Dubai courts have properly given effect to the business exception and the banks have misinterpreted it, the remedies are different. It may be then that it's necessary to do something in relation to the banks rather than in relation to the court.
But the banks have done what the banks will do when they receive an attachment order from the central bank. They'll lock the accounts and they'll just debit them.
Well, it really does depend on what the Dubai court has done, doesn't it? Seems to me.
Well, no, we say no, because the effect of what has happened, one just looks at the effect of the consequences of Your Honour's order. If the consequences should not be this, if there's another solution to this problem, if that's Your Honour's concern, is there another solution to this problem? No one suggested it. We've been trying to get some other solution to it. No one has suggested that there is another way around this. And we would suggest it's not realistic to say, well, let's just keep writing to the banks. So the bank's position, and this is not a problem that is completely unknown to the English courts either. Your Honour may recall that at the first hearing, I took Your Honour to authority in England, which suggested that it's generally, even with a business use exception, as a matter of principle, it's generally not appropriate to make those sorts of orders against functioning businesses, functioning groups, because of the practical consequences that follow. So the practical consequences that follow are that sometimes, quite often, when faced with these sorts of orders, a bank in England even will say, well, the business use exception, but I can't tell whether or not this payment does or doesn't fall within the business use exception. And as a result, I'm not going to allow any transactions on this account. But the result of that, if that is happening in England, is that the court won't make that order in the first place. Now, that consequence is not the result of Your Honour's order, so there's no problem with Your Honour making that order. That consequence that we have here is the result of the way it's been implemented onshore. And that is not within Your Honour's gift as to how it's being interpreted and applied onshore. But there's no principal difference between the question of whether, between the situation where the problem is being caused by the local courts or the problem is being caused by the bank's reaction to the order from the local courts. That's just the consequence of the way it's been implemented onshore. And so the answer is, unless Your Honour is going to go back to the position that we had right at the start, which is, well, tough, Aria DMCC and now Aria Bio just have to live with this situation. DMCC can't even process payments in, neither company can process payments out. And unless that's where we're ending up, then it seems to me that there's no other option than to remove these attachments. And then the question is, what's the harm to the respondent in relation to the claimant in relation to that? It's quite difficult to see what the harm could be. I mean, one option, one of the part of my learned friend's submissions is that, well, there's hardly any money in these accounts. How can it matter? Therefore, this is tactical.
Well, we've seen this 40 million euro, one of them.
Yeah. So one way to do it would be to fund an account and remove the attachments in relation to all the other accounts, or do some other, but none of that is being proposed. What all we're getting is a flat back saying, that's your problem. We've done our bit. Go to the Dubai courts if you want something different. And the reality of it is, in the meantime, these entities cannot trade, and they're having to effectively circumvent the order to stay alive, which is in nobody's interests in my submission. So, I mean, that's the choice that Your Honour has, ultimately. You can maintain the status quo, and then for the next 3 months or whatever it is until we get to return date, Aria DMCC and Aria Bio cannot really use their money. There can be no suggestion that they can use the money. I've shown you the accounts and they've just been debited, so that's gone. There's nothing they can do. The suggestion that that isn't going to cause business disruption is, we say, fanciful. You would be stopping a trading group in its tracks, and that is not the role of the courts. So the alternative is to release the attachments. I don't even know whether it's possible to remove attachments over specific accounts, but ultimately the problem has come in the implementation of the order through the Dubai courts. And if one thinks about what an attachment actually is, and that's the question I suppose that might be in your mind, is the problem at the Dubai courts end, is the problem at the bank's end? I mean, what is an attachment? It's effectively an in rem remedy over money. And the result is that they've got a number, which is 450 million, and each account has been debited for that whole of that money, not the whole of that number. It's difficult to see how the banks could say they're supposed to implement it in some other way. But even if they implemented it only 450 million across all of the accounts and divvied it up one way or another, you'd still end up with zero balances because there isn't $450 million in there to start with. So if it matters, the problem is not the bank. The problem is the order. It's the attachment in itself. It doesn't matter because what matters is the outcome, and the outcome is not what Your Honour ordered. I think those were my submissions on that issue. So unless you've got any questions for me at this stage. Great.
No, thank you. Thank you very much indeed. Thank you. Mr. Holloway.
Your Honour, I realise we've just taken a break, but might I ask for a 2-minute further break?
Yes, of course.
For personal reasons.
Yeah, of course.
Sorry.
So we'll come back at 12:30.
Thank you. Incredibly kind of you, Your Honour. The alternative would have been rushing this too much, so thank you. I'll start with the numbers, which is where you began, and you asked Mr. Montague-Smith about them. I think the clearest place that they're set out is at page 4450. Sorry, that's wrong. It's 4550. I do beg your pardon. No,
4550.
yes. So you'll see a table there that Kroll have compiled, which has all the accounts, and what they've done is they've applied the attachments to what was in the account at the time, and so that's the state of the accounts before the attachments, if you like. So that shows you that there was nothing like 30 million in any of those accounts. In fact, there was very, very little there at the time at all. And where they got that information from, Your Honour, is from the onshore Dubai execution judge and the letters that were exchanged with the banks in that procedure. So I'll not take you to those, but they are exhibited at 5668. There's about 20.
It seems inconsistent with what was shown to me by Mr. Montague-Smith in relation to the two ADIB accounts.
Yes.
So I do need some help reconciling.
Well, that what Kroll have done there is they've taken 20 pages of correspondence from the courts and the banks in the onshore proceedings, which are 4668 onwards, and they have taken what the banks have said were in those balances, and they've applied the attachment and calculated what would have been there before. So that's their analysis of it.
If there is any point in this, and Mr. Montague-Smith presses me that and the position is that at least accounts with two accounts with substantial amounts in them have been effectively completely frozen, then I need to be able to understand the reconciliation between what you're telling me and what he told me.
Well, I'm telling you what I'm telling you, which is what we've seen from the court.
Yes, well, show me how those figures. So let's just find the two ADIB accounts that Mr. Montague-Smith referred to, and let's see what the information is in relation to them.
Well, we'll try to do that. Yes. So it's at 5668 is where the run of documents.
Well, let's just start. Shall we just start with identifying the accounts that Mr. Montague-Smith referred to, which is at 6071.
Well,
then we can get the numbers, can't we? So the two accounts then are the dollar accounts and the euro accounts. So the dollar account number is so 190 is the common 190 1255.
1255. We have 12559.
12559, and the other one is 190 49329. 493.
Right. Yes. So according to.
Let's go back. So sorry. Let's go back to page. What's it?
4550.
4550.
You'll see the 559 account.
Right, 45, yes.
$120,000 in it, and the other one that you mentioned
which is 49329.
Sorry,
Yes.
could you tell me what page we're on? I've lost that.
4550.
4550.
And the last one that Your Honour mentioned, 329, that had a grand total of $1,800 in it.
Where do I see 329?
It's just at the bottom of the added columns.
Euro. Well, it just says euro.
Yes,
No, I've got it. I found it.
Yes. And then where that comes from, if I could turn you to 5580.
5580. Yeah.
That's from the bank itself to the court, answering the request to identify.
This is the 9th of April. Balance is today's date, 190. Yeah, I've got, okay, I see that.
So if we go back, I mean, we can go through them all, but what
No.
Crawl have done, they've taken those letters from the courts.
Where's 329, where's that? 329's there, yes, I've got that. 1,800 euros.
Yes. So that's where that comes from. It comes from the banks themselves, as when they were asked to turn out what they had, they wrote to the onshore courts and told them that, and Crawl put those figures in, applied the balance, and there you see what would have been in all those accounts before the attachment was applied on that basis. So you can see there was little, if anything, in those accounts at that time. Your Honour, that's number one.
Yes.
And then a related point, if we scroll up to 12.6.4, one page up, I believe.
Sorry, what page?
4549, that will be at.
4549. Yeah, let's have a look.
This is the correspondence. This is what Crawl said. They actually didn't know about we didn't know about a lot of these accounts until the courts had actually written to us. The onshore courts had written to the banks, and the banks had disclosed that there were more accounts than we had previously known about. And I just want to make the point that that's how Crawl got the information that we got. It's because the onshore court, as a procedure, allowed the execution judge to write to the banks, and the banks then were instructed to tell us what the accounts were and how much was in them. And that's enabled us to compile the table, which is on the next page. So just in terms of the way that was done, it came about through the court execution of your order. And although there were, if you look back again at the table on the next page, 4550, you'll see a couple of those accounts were not mentioned by Mr. Britton in his asset disclosure. He says it's because they didn't have any money in them. He later says that. And also, we only knew about one ADIB account, one ENBD account, and one MASHREC account from the payments being made. We now found out that there were more. And so that I think just tells you the process by which it's been derived. So I could perhaps leave that there, but it does show you that there was very little, if anything, in those accounts at the time the attachments were made, which we can develop a little bit later. But the next document I wanted to show you on the same point is Mr. Britton's subsequent asset disclosure, and it's 3717. So after the this is his latest position of all the accounts from Aria Dmcc. They are highlighted in blue, and I can say no more than that even Mr. Britton admits in that asset disclosure there's very little money in those accounts at all. I think there's one account that has $1.8 million in it. If you scroll up to page 13716, but that presumably was before legal expenses had been deducted. We think it was before, but in reality, both Kroll and Mr. Britton agree that there's very little, if anything,
And we don't have account numbers for these.
No. So that's point number one. Next thing I just wanted to address is how I think Your Honour asked how
we may have. Sorry, some of them do have account numbers.
Oh, sorry, some of them do. 9324, yes, is there, but some of them don't. Yeah.
(9324), but not 9329.
It may be included, but not named per se, but we don't.
That's an AED account. We have a euro account. Assuming, well, there are only 4 accounts given.
Yes, I think that's
there by ADIB. So 2728 must be the relevant accounts.
We would think so. There seem to be 4. That's not accepted.
Oh, there are only 2 euro and US dollar accounts mentioned there with ADIB. Okay. Oh no, there's another. Oh, that's Aria Bio. Okay.
Yes, indeed.
Okay. Sorry, do carry on.
No. The next thing I think Your Honour was asking how these orders would land with the bank. The first point to make about that is that the banks have been notified of all the orders made in this court automatically because they are parties to these proceedings. So Your Honour will remember they were actually part of the first hearing. And also, if you look at page 5593, we clarified in that email, paragraph 1, that as soon as your variation order had been made, the banks were already aware of it because they were notified of it by the DIFC court. And I haven't exhibited that in the bundle, but there's an email of the court on the day that you made the order notifying all parties, including the banks, that the order had been varied. Now, in answer to your question, how would such an order land with the bank? The answer is quite simple. The banks, to the extent that they're located in the DIFC, have to obey your order. The banks onshore will also obey your order as long as the Dubai courts tell them that they can. And we say that's actually what's happened. They've been well aware that the order has been varied, they've been notified of it, and they are also aware that the onshore courts have executed both your original order and your variation order. So there is no reason to suggest that the banks wouldn't have comfort in complying with the orders because they've been made by both the Dubai courts and Your Honour in the DIFC. So that's just general background. Now, then we get to what happened on the ground. I think the first thing to say is that the original order, it took quite some time before the onshore courts enforced it. They didn't enforce it until the 2nd of April. So that's more than 2 weeks after you made the variation order. So the original order took quite some time before it was actually declared enforceable onshore. In that whole intervening period, effectively, the banks were not obliged to do anything. So it seems like there was no harm or prejudice or difficulty that could possibly have been suffered by the first respondent up until the 2nd of April. When the 2nd of April came, they were notified that the attachments had been made, and they immediately complained. And you'll see that at page 6223. So that was on the 2nd of April, saying we've just got this order enforcing the first order on shore. And then significantly, paragraph 5, it says we're now prevented from using monies in Mashwat, Emirates MBD and Adam accounts. And in fact, that was wrong because Emirates MBD accounts had been closed a year before or 7 months before. But that was their position on the 2nd. Now, from that point, we have taken every step conceivable to make sure that your order was being enforced in accordance with its terms, including the variation provisions. And it's really, quite simple. The orders that you make, Your Honour, are directly enforceable onshore. There's your order at paragraph 5 said that, but even if it hadn't said it, it would be the case as a matter of principle. But nevertheless, having received a complaint that this order was being operating outside what Your Honour had envisaged, we have taken every single step that we could to make sure that that wouldn't happen. So we've immediately on the 3rd of April wrote to the courts and applied to vary whatever they were doing to make sure that it was in accordance with Your Honour's varied order. So that's, you can see at page 6224, I think there was a question of when this first happened. What was the first step we took? Paragraph 2, we've got your letter. We immediately filed a request that the onshore courts clarify that the order would be enforced as varied. And then we were told, paragraph 3, sorry, am I getting, so, there was correspondence between QE and Altamimi throughout this period. The next letter we wrote updated them a week later. That's page 6244. So we again repeat, we made the first application on the 3rd of April, and then paragraph 3 on the 4th of April, they told us that we needed the execution formula in order to make the application effective, i.e. we made an immediate application for the execution judge to take into consideration your order and make sure it was executed in those terms. And we were told we need a formal letter from the court to do that, which we immediately applied for. And then significantly in parallel, paragraph 5, because we knew that would take a little bit of time because it does with the court, we also went back to the Dubai court to try to find another way to notify the banks that they were allowed to let first respondent trade in the ordinary course of business. Then we were told again on the 6th of April, paragraph 6, that we needed the enforcement seal and deputization letter. We got that. We applied again, paragraph 8, on the 8th of April, and so on. What happened then was the execution judge agreed, and we see that in page 6296. We clarify paragraph 3 of that letter. On the 14th of April, the execution judge approved the request to write to the banks to tell them that they were permitted or one was permitted to withdraw funds in the reasonable for business purposes in line with the variation order. And then we were chasing the letters to the banks, and those were issued. So there really is no question, as things stand, that your order has been recognised and is being enforced in accordance with its terms, and that the banks have been told to comply with that in the usual way. Just noting paragraph 6 of that letter. Sorry, Molly, can you? On the 17th of April, we asked, can you, the complaints that you've made about your business being imperiled, can you please give us details of how that is, how the damage that's been caused, because we hadn't really had any clarity on that. And the variation letters were sent on the 22nd of April. And then let's come back to that question. And again, sounding like a broken record, but we have to look at the actual evidence. So, the procedural point is that the orders are now recognised. The banks have been told to obey them on the 22nd of April. And then we have to look at, has there any harm been done? Has any damage been done by virtue of the fact that it happened on the 22nd of April? And this is where, once again, we have to look at the actual evidence, not the assertion, and not the sort of, say-so evidence, because there's lots of that. There's lots of stuff in Mr. Britton's witness statement where he says various things have happened, but can we look at quickly at the exhibits that he has produced? Because once again, when you drill into that, there's really nothing. There's nothing there. What's happened is there's been a little. They've picked on this. That it took some time to get the variation order recognised, and they've jumped on that in order to set the whole thing aside onshore. Now, I want you to look at the evidence before Your Honour as to what the actual harm they say that happened, whether it did happen or not, and bearing in mind that as of the 22nd of April, as far as we know, the banks have been told to enforce your order as varied. Looking through the two exhibits, MWB 8 and MWB 9, and I'll just skip through them quickly, starting at MWB 8, and it's at page 32 of that exhibit, 5293. And if I may, I might take this in paragraph number order rather than.
Well, let's try and just get the page up.
5293. Sorry.
Yeah. I've got 5293. Yes.
Yes, that's now. If we can skip forward to the exhibit, page 32 of the exhibit.
Sorry, I mean 5293 takes me into the last page of the witness statement of Ms. Lee of 17th April.
Yes, I think so. 5890. I'm so sorry.
Okay.
So page 32 of that.
5890.
You got a page 32 things. 5923.
Okay, I've got NWB 8.
Right, so page 32 of that. I'll have to get this up before I can. Okay, so yes, it's 5923. There's an invoice there, 31st of March 2025, payable by Aria Bio, and it's to do with buses. That's it. We've got an invoice. We don't have anything, evidence about difficulties paying it or anything from the bank saying why it can't be paid. And it's also Aria Bio rather than Aria Dmcc, and I'll come back to that. But again, all of this, it's the same, 33 and 34. There's another invoice And yeah, apparently this cannot be paid, but we have no information as to why or how it can't be paid. It's another Aria Bio one. Page 35 is a SALIC a record of work done for Aria Bio by SALIC. No evidence of why that can be paid or not paid. 36, tax invoice by Wonderwall Contracting to Aria Bio, 3rd of April. No reason why it can't be paid. No reference to any bank details or confirmations. 37, 38, and 39. Similarly, this is an email from Filet à la Maritime regarding unpaid invoices. It doesn't explain why that invoice wasn't paid, anything to do with the banks, etc. Skipping on to MWB.
So let's just, and then we get to that document account summary from Adib. Report generated 25th April by Matthew Britton.
Let's see that. That's where is that? That's
5931.
yes. Well, we have that. We've seen the account balances. We've seen we've seen what crawls say about it. I don't have anything else to say about that. I'm looking at the evidence in relation to problems with payments.
No, I understand where you are at the moment. Okay, carry on.
Okay, I'll skip to MWB 9, which is should be, I hope, at page 6073. Yeah, I'm going to look at 6073 first. Let's see if that's no, 6703 to 77 is a bunch of emails between Aria Commodities, not clear who that is, and Shell to do with an unpaid invoice. No invoice was supplied with that. It's not clear what it's for, who owed the money, or why it wasn't paid. Going to page 35 of the same exhibit. Another invoice, SPM shipping charter hire in May. That's it. It's an invoice. Nothing accompanying that showing why or how there's difficulties paying it.
Sorry, you're on page 6078.
Yes.
So that's to bio then.
That's bio again, yes, indeed. Over the page, another invoice to bio, but again, it's an invoice, it's nothing more. And 37 and 38, another one to Aria Bio, payable on site in March 2025. That's before the attachments were even in place. But there's really little information beyond a bunch of invoices here. And would say the same for all of it. Page 39 and 40 is a tax invoice. It's a bunch of invoices. But when you look at all of this in the round, it's a bit like the damage to the business that was being suffered at the last hearing. It's pure assertion. There's no evidence as to why these invoices, whether they were paid or whether they weren't paid, or why they couldn't be paid. There's no correspondence with the banks at all, showing any difficulties with the bank accounts. There's no evidence of any difficulty receiving money apart from assertion. And And if we look, for example, at page 5932, this is another statement exhibited by Mr. Britton in relation to the Mashrek accounts. But if one looks, this shows also the accounts with Aria Bio. If we can scroll down, sorry. Yes, so the fourth entry there is Aria Commodities, account number Aria Bio. There are two accounts there. Neither of those show any block at all. They show credit.
Sorry, where are you? Sorry, where are you looking at? You've lost me.
I'm sorry, Your Honour. I'm trying to. It's page 5932.
Yes, I have that.
Now, if you look at the account name column,
Yes.
you see Aria Commodities, the first one, and that's got a block on it, minus 164 million or whatever it is.
Yes.
Aria Bio has a credit in it. It doesn't have a block in it. It is not overdrawn. Likewise, the fourth entry. So there's no real evidence that Aria Bio have been affected by this attachment at all. And it would be very strange if they had, because my experience of the onshore courts is they're quite sticky about attaching things in exactly the name of the accounts that are and the party that is mentioned in the order. So looking at that as a whole, I submit it once again a completely evidence-free zone. It is assertion. There's nothing to tell you what's happened with the banks at all. So it just doesn't support the order that they're seeking. Now, legally speaking, Mr. Montague-Smith, I think he doesn't press this, but I think the original application was made on the basis that we behaved unconscionably or oppressively, and we were trying to kind of behave badly. That's not been pushed today, and I submit there's no evidence for that at all when you look at exactly what we've done to try and help them. But he then says legally this kind of order that he's seeking is, quote, not unprecedented in the DIFC. And that's, in my submission, no reason to say that an order should be made. The fact that it's not unprecedented that that kind of order will be made. There is a world of difference between the SCAT Elysium case and this one. I think the first one you pointed out was that it wasn't a proprietary order. I take my learned friend's points about the business use exception being applicable in both. Paragraph 3 of that case, looking at 7364. Sorry, it's not. It's further up. Paragraph 7, page 7363. Paragraph 3. Sorry, no, I'm looking for the reference where Jeremy Cook says. Oh, sorry, yes, I got it now. The words used was pro tanto, and you find that at the bottom of paragraph 7364. Where is that? The last line of paragraph 3. It was paragraph 3. Pro tanto is the operative phrase. In that
Sorry,
case,
let me just catch up with you. I've been shuffling backwards and forwards. Paragraph 3, 7, 3. 7, 3, 6, 4. Okay, so we want paragraph 3. Yes, I have it.
So you had in that case two payments that were found definitely to be caught by the onshore order, which shouldn't have been. And the solution to that was a pro tanto release from both, so that those payments could be made. So there was proper evidence before you of a difficulty, a salary payment that couldn't be made, and a release on that basis. You don't have anything like that in this case. You've just got a general kind of allegation that there have been problems. I think even today we're being told that the idea that they couldn't receive money into the accounts has been solved. I think what that shows is that whatever these complaints are, they're old, and they've been solved by the fact that the onshore courts have enforced your varied order. There's no evidence to suggest the contrary after the 22nd of April. But if I can leave you with one final thought on this, it would suit them very nicely to have this order, the onshore enforcement of your order discharged, and a get out of jail free card from the Dubai courts. The reason that we need the attachments to continue is precisely because it's the onshore courts who are catching the bank accounts, and can find the information that we need to help us trace. Again, I do maintain this is a tactical application. The enforcement of your order is a matter for the Dubai courts, and the rules say that those orders are directly enforceable. There's no evidence that there's been a problem with the way the banks perceive this. There's no evidence that the Dubai courts have not understood it. And even Jeremy Cook's point that it isn't possible to vary an attachment, I think that's been shown to be wrong, actually, because what we've done exactly that. We varied it in accordance with your order, and the banks have been told that it's been varied. So the banks are perfectly at liberty to allow it. I think the real problem is what we've seen at the beginning. There just isn't any money in the accounts, but we're still getting to the bottom of the bank statements, how many bank statements there are, etc. So it can't possibly be a case for releasing these attachments at this stage. That's my 2 cents worth.
Thank you very much indeed. Mr. Montague-Smith.
Yeah, thank you, Ryan. I'll be as I can. The first thing I would point out is that for the first time we've heard from my learned friend that they took no steps to tell the Dubai courts about Your Honour's variation until the 2nd of April of this year, which is around 2 weeks after the variation was ordered. We would suggest that that is totally inadequate. They should have gone straight to the court immediately and said what there is now in place needs to change. And we've seen that it takes some time to push these things through the local courts. So the idea that, well, it doesn't much matter because we waited until the 2nd of April and that's when the attachments actually started to bite, so there couldn't be any harm, means that they can't be criticised for not going earlier. It is, in my submission, unreal. My own friend says, well, there was the shadow of a suggestion that there was no, criticism, but wasn't pushed too hard. The reason it wasn't pushed too hard is we didn't know the full story. And so when we wrote on the 2nd of April, we were then told on the 3rd of April an application has been made. And then immediately they hear back on the 3rd of April, well, you need to go through the Dubai courts. And that application is then made on the 4th of April. So the impression we had was that there had been some back and forth between them and the court prior to that, which emerged on the 3rd of April with the judgment that you need to go to back to the Dubai courts. In fact, they sat on their hands for 2 weeks. And you just have to ask yourself, is that appropriate in a case like this? That's not the centerpiece of the application. It is relevant to the application, but it's not the center. The central point I make is, if it is right that there should be business use exceptions, and it is right that the effect of your order is that there are no such exceptions, and that is the result of the attachments, then the only principled response is to remove the attachments. My learned friend took you to evidence of what was in the accounts, and I suspect I may have set hairs running in relation to this. The submissions that I made to you were, as I say, I was going to try and take instructions on those documents, but I was saying the implied balances. Looking at those documents that we looked at page 6071, were only based on mathematics by deducting what I understood to be the value of those of the money that had been deducted in the various currencies. And it may well be that my learned friend is right, and that document at 5580, which I confess, amongst the 8,000 pages of documents we have not focused on, may be what is the most accurate statement of what was in those accounts. My client doesn't know in relation to Adib. You can see that in relation to Mashreq Bank, but these are trading accounts, and so all we've got, as I understand it, are those statements that I took you to, showing what the banks say currently are the statement of account. In relation to Adib, those include the deductions. If we go to that, though, if you look at page 5580, and I would say it rather solves the problem, for Your Honour, because what we're talking about at this point is $120,000 and then 16,000 dirham and then 13,500 dirham and about 1,800 euros. So if you add all that up together, you don't get really to anything much more than about 100. Well, I hesitate to embark on another mathematical adventure which leads us down the garden path, but
you say not significant sums.
It's not a significant sum. And so and my learned friend says, well, there's no evidence, boldly says there's no evidence of any harm. He just says, well, there's only a bunch of invoices. One might ask, is it being suggested that those invoices are fabricated? Is that what my learned friend's submission is? Is he suggesting that Shell has not emailed my client demanding payment of $300,000, unless he's going to go to
emailed bio?
Emailed, yes, emailed bio, but to take it in stages. So there's invoices to DMCC and there's invoices to bio. So my learned friend says, well, it's just a bunch of invoices. These are demands being made for payment. Unless it's being suggested that those are simply forgeries, which even my learned friend and his ghost asset allegations isn't willing to go that far, then it's quite clear these are entities which are trading and need to make payments. And one doesn't have to think too hard about why that might be the case. So the idea that there's no harm that is occurring to my clients, both DMCC, I'm not acting for bio, but for their subsidiary bio, as a result of what is happening on the ground, is remarkable in my submission. He then says there is no evidence that Mashreq Bank are preventing the operation of the bio accounts. That's not true. Mr. Britton has given that evidence. He's given it in his fifth and sixth witness statements, and I took you to some of it. It's at page 5885, paragraph 24, and you will see an update at paragraph 6039. The position as it stands, I mean, what does my learned friend want from us? We have to extract, do we, from the bank a letter saying we will not operate this account. We will only allow payments into this account. But there's no reason, there's no countervailing evidence. And why on earth would we make that submission? What does it come back to? It comes back to, firstly, the point of principle that we make, which is that you've already said we should be entitled to operate these accounts, and we can't. And second, if one wants to revisit that assessment, what's the balance of prejudice here? You've got $150,000 sitting in these accounts on my learned friend's own evidence, and that's his position. The Mashreq Bank evidence does tell us what the account balances are, and they are very small. So those are at 6072. So we can see what Mashreq Bank says are the balances, and they come in at 19,000 dirhams and $2,500. So what is the benefit to my learned friend of locking those accounts? He gets to maybe keep that 150,000 if his client turns out to be right in Hong Kong. What is the harm to my client of locking down those accounts? It is that my client can no longer receive payments into those accounts and use them to operate its bank, its business. And that $150,000 is, while not significant in the grand scheme of a $533 million claim, significant in the operation of the business. Ultimately, the only solution is going to be to have to route payments around these accounts. Why would we bother doing that? What possible benefit has that got to my learned friend, and what possible interest could the court have in making that sort of order? So in a sense, we say my learned friend can't have it both ways. He can't say there's no harm to you because the values are too low, but on the other hand say, but it's absolutely essential that we lock these accounts if the values are so low. And the solution that he seems to suggest, well, the other point that he makes is that this is all important for tracing information purposes, but they have that information, or they have the information that they're going to get in relation to that. It's not suggested that there's another stage in front of the Dubai courts which goes further than the information that's already been provided. So that's a bad point. And then the answer seems to be from him that, well, we need to, if this was going to happen, it should only be pro tanto. So you should authorize the release of all these individual invoice payments and somehow manage it as if that's going to make any difference to either the courts or the way that the order's been operated, which is to debit every single account for $500 million US in relation to DMCC. In relation to Aria Bio, of course, the bank shouldn't be operating in this way, but it is having an impact. It's a third party that is affected by the order. And my own friend said, well, there's no evidence of that. There is evidence of that. There is, from Mr. Britton. Unless you decided that Mr. Britton is a fraudster and can't be trusted to say anything, there's no evidence to countervail that. And why on earth would he lie about it? To what? To support an application to release $150,000 in the context of this claim. It doesn't make any real sense. So we say, A, principled, the order is the order, and it should be implemented in accordance with the order, and if it's going further, the only answer is withdrawal. And B, actually, pragmatically and practically, on my learned friend's own case, this is about the difference between preserving $150,000 on the one hand and stopping a business from functioning on the other. So unless I'm given any instructions that I need to deal with anything further, or unless you have any further questions for me.
No, I don't.
Very grateful. And I apologise for embarking on what turned out to be a wild goose chase. But my instructions are we simply don't know what's in those accounts, but the prospect of there being 40 million euros in them seems to be very low.
Okay. Right. In that case, that just leaves the question of directions.
Yes.
Which I think is, I think you're taking the lead on that, aren't you, Mr. Montague-Smith?
I will, if you like. Yes, absolutely.
Yeah.
So the first issue is the timing of our evidence in response to this. And then the second is the issue of listing of the hearing. There may be a third issue that my learned friend has introduced, is whether he can have another go at producing further evidence and no doubt further allegations, but we can deal with them in that order if we may.
Yeah, of course.
In relation to the first issue, timing of our evidence, we're seeking 6 weeks for that. It's a substantial undertaking. And we obviously need to find an expert from Standing Start to instruct, clear conflicts and all the rest. And so my learned friend suggests 2 weeks, which is just another example of him trying to make this into an unfair process. I mean, the bottom line is we probably need to fix a hearing date anyway, and if we works back from there, there's very unlikely to be any reason not to give us a reasonable time, and 6 weeks is, we would suggest, a reasonable time to put together a response to the complexity.
If I go to the hearing date, fortunately, due to a cancellation, I am free the week commencing 30th June, which I think the suggestion was the first open date after so 1st July. I do not have any time before then. literally.
You don't have any time before. Do you have time
before
after?
the 30th June? After, yes, I do. I do. I have. July is relatively clear for me, but if and insofar as I'm afraid the claimant was pressing for an earlier date than the 30th of June, I couldn't do that.
Thank you. All right. I need to. So if we were to serve our
30th of June is
evidence,
the earliest. 30th of June is the
Yes.
earliest date I can do, and I would like to do the earliest date I could do.
I understand that. I need to take some instructions in relation to availability. I think the bottom line in relation to timing is that my own friend has his order in place in the meantime.
Yes.
And if it is a question of pushing things back by 2 to 3 weeks from the 30th of June to give us sufficient time to do a proper job on the evidence, then we would, while we want to get rid of this order sooner rather than later, we would ask for enough that the court prioritise giving us sufficient time.
Well, do you want to give me a date we can work back from? I mean, I don't mind. We've set aside until 4:30
Yes.
today. So
Understood. So I was going to suggest 23rd of June for our evidence, which is 6 weeks from today,
Yeah.
and then 21st of July for the hearing. I haven't checked that with my team, but I'm sure they'll shout at me if I'm wrong. And if we work back from that, that would mean skeletons on the 14th of July to give everybody sufficient time and there be no surprises.
yes.
And then the bundle to be provided by the 7th of July. And that will give a bit of time to put the index together as well, which I was going to suggest should be agreed on the 30th of June. Because I would suggest it's not in anyone's interests just simply to continue adding to the 8,000 page bundle that we already have.
No.
We should start again and provide you with a proper bundle, which is reduced. So that was the timetable. I mean, I'm sure elements of that can be compressed, but we would ask you for 6 weeks for our evidence, and that sort of drives the timing to some extent.
Let's just see very quickly what Mr. Holloway says in the last 10 minutes we have. Mr. Holloway, you're on mute.
Yes, yes, I know. Sorry about that. So first thing I think we need to probably clarify is what is coming in next from the respondent. Is it just?
Well, you have you have my order that I've given them. I've given them permission to serve a rejoinder and the expert evidence in 2 disciplines.
So that would be more evidence from Mr. Britton and expert evidence, if I'm getting that right.
Yeah. Well, I assume so. I mean, it may be the rejoinder may come from another person, but it's been Mr. Britton
yes.
so far.
So if that is the case, it first of all, it is inevitable that we will need to analyse that information, and it is inevitable that Kroll will be doing that. So I think we have to be realistic here. There's new evidence coming in, and we will need to deal with it and respond to it. So I think that's my first point.
Look, I mean, a lot of the stuff here is, I mean, actually, a lot of the Kroll report could just as easily have been made by way of submission, rather than in the form of reports. I don't want to get into a sort of battle of reports. I mean, if you're advised and you analyse some of the evidence that comes in, and you make submissions in your skeleton about the inconsistency between one account as to an asset value and another. That seems to me just to be a simple submission on the facts. It doesn't really need expert evidence. You say that.
Yeah, well, you say that, but at the last hearing, I said I wanted longer than 2 weeks to analyse, and I was set upon by my learned friend. In fact, we had longer, and even with Kroll, crunching through this stuff, it did take that long. And we did it in 3 weeks.
Well, that's timing. That's different. I mean, I'm not. But what I'm talking about is I thought you were taking a run up to asking me to order a yet further report from Kroll, because the answer to that is no. By all means, Kroll will assist you, but we have to draw a line under. You've got 2 reports from Kroll. This second report from Kroll, I didn't think was necessary to be a report anyway. It was a matter that could have gone into submission. And if the putative third report is of the same sort of quality, then it goes in your submissions. It doesn't necessarily have to.
Your Honour, I have to push this, because one of the things that we've asked you for today is disclosure of further information. I will need Kroll to help analyse that, and I will.
Of course, I'm not suggesting that you don't need Kroll, but what I'm saying is that their work product doesn't necessarily have to be a report for exchange. It's something which can be given to you by way of instruction, and you can make your submissions, because they're factual submissions at the end of the day.
Well, the other thing
it's not expert evidence. It's not actually expert evidence, you know.
It's not, but you have made the point yourself previously that you would be assisted by expert analysis or professional analysis of this information.
Yeah, but it doesn't have to be in the form of an expert's report. It can be in the form of your submissions assisted by experts.
So
we're just arguing about form and substance, and the reason we're arguing about that is I don't want to be ordering more experts' reports.
Well, then the next thing is
that doesn't stop you having that assistance. It doesn't stop you putting the product of that assistance to me. It's just a purely procedural point that I'm making.
But if I don't know if we're getting a third or fourth iteration of Mr. Britton's story with further disclosure, I submit it would be helpful to the court to have a brief response from Kroll. After that, I don't need to take too long over it, but I think it is fair. I think it is fair, and it would.
You can, of course, you can have assistance from Kroll in responding to it, but you can make the submissions. You can cut and paste Kroll's instructions into your submissions, but I am very much opposed to ordering a further explanation.
I mean, you could say that for both sides. We could sort of disregard, but if we're having these people in, it helps to have reports. It structures.
My learned friend's got nothing. It's not assistant.
Quite a long time on your version of the directions.
On directions.
If on timing, we had 3 weeks to put that Kroll report together, and we were borne down upon for asking too long. Now, it can't be that we have 6 weeks and then no time to analyse it before the hearing.
Now that's a different issue, and I'm content. I'm content with that. Let's talk about timing. Let's talk about timing rather than
to back that up. I mean, this is analysis of their own financial. They've got all of this information. They've always had it, so they don't need 6 weeks.
So, what do you suggest? What do you just give me a suggestion and then justify it?
I would say 3 weeks maximum, like we had, but they've already had a week to look at this. They should have instructed someone already. I think 3 weeks.
This is the judgment of Solomon. They've got, all right, I'm saying 4 weeks.
And then I'm absolutely happy with
what date does 4 weeks take us to?
That takes us to the
9th of June.
The 9th of June, yes.
Okay, so 9th of June.
And I'm happy with the 21st of July. That I can make that, and I think that's sensible because we will both need quite a bit of time to read into what comes.
So 21/7 hearing. Okay. So what do you say about the third? I think the next date Mr. Montague Smith proposed was 30th of June to agree an index.
I don't object to that at all. I think that's
okay.
Fine.
So agree index, and then bundle 7th of July. Yes.
It's fine with us. Yes.
Okay, and skeletons 14th July. Yes.
Also fine with us. Yes.
Okay, you see, there we go.
Uh,
Good.
Your Honour, just one point from me, which is taking a leaf from my learned friend's book, just to point out what you've ordered is that we produce the expert report on the 9th of June, and then nothing much happens until the 30th of June, and skeletons aren't due until the 14th of July. 1, 2, 3, that's 5 weeks before the report and skeletons, which gives.
I can bring the hearing forward. I'd be happy to do that.
No, I'm not suggesting that. What I'm suggesting is that if it's right, we should have a proper opportunity to prepare a report. Why put the first respondent under that additional pressure of time? My learned friend's specious points about they should have instructed someone by now. I mean, it's not, that is not a fair response, because it's not a straightforward thing to do, to go and get an expert.
Look, I'll tell you what, 16. I'm just trying to be pragmatic.
Your Honour, can I just reply to that? The reason we need the time is that whether or not Paul put a report in, we're going to have to spend quite a bit of time analysing it and collecting our thoughts to it. So I think that's what we agreed was fair. And if it can be done, it should be done.
No one agreed that. So
hold on. So if you have 4 weeks and you're going to put in additional evidence and 2 reports, then what we're looking at essentially, and from the 9th onwards, we're looking at 3 weeks, aren't we?
No, that's to the indexes. I mean, I'm concerned that 4 weeks just isn't enough time. So I'm being instructed that is not going to be enough time.
Okay.
One thinks about dropping a new expert into this. Why put that pressure on us? It's just setting an impossible task at this stage. Kroll have been in this case for years. The idea that somehow it took them 3 weeks to put that together, so we should have 4, is not a fair comparison. They've been in this for 3 years or something. So I mean, really, well, I'm being told that 6 weeks is kind of the bare minimum. But there we are. We're in your hands.
6 weeks. 6 weeks, you say, takes you to the 25th.
23rd of June.
23rd. But that does 23rd, then 14 days after 23rd.
We really need more time to respond to that.
No, so the 23rd gives 21 days. There's 3 full weeks after that for exchange of skeleton arguments, which is the first date. The other 2 dates in between are simply agreement of the index and preparation of the bundle. So they're not really an issue. The issue is the 14th, which is 3 weeks. So from a standing start, we're supposed to produce expert reports within 4. I would press that, just because, I mean, if the hearing needs to go back a little bit, even further than the 21st, if that's the problem, then we can do that. But the report,
no, it can't, because I'm going on vacation the following week. So 21st of July has pushed it back as far as you can.
All right. Well, I mean, then realistically, does Your Honour think that compressing them to 3 weeks for consideration of all of our evidence, preparing for the hearing, and getting it into a skeleton, and then having an additional week to prepare for the hearing is unfair? I mean, ultimately, my dates still give us 4 weeks before the hearing. We're providing that evidence. The other thing is, Your Honour makes the point that these things points can be made in submission, and I do reiterate the point that we made and just put a marker down that we do say, if you're going to prove fraud by inference, you have to explain what are your primary facts, and you can't just keep lobbing new facts onto it, and that's part of the problem here.
Well, that's what I'm suggesting. Is not what I'm suggesting. It is that, if you like, the response to your evidence, the evidence is frozen, and it's after that it's analysis of evidence. It's not additional evidence.
Well, analysis of evidence, yes, but the problem is that what happens is you get another set of allegations which aren't necessarily evidential, but which have responses to them. So Your Honour did it to some extent in the judgment, but not obviously in a conclusive way. You said here are some red flags. Now, red flag means part of an inferential case for fraud. That's really
yes, it means something.
I
mean, I had to consider whether or not there was a serious issue.
Yeah.
In relation to fraud, and I perfectly frank, I'll reiterate it again. I was strongly disturbed by what I saw.
Well, no doubt you haven't reached any conclusion on that. But what I'm saying is all of those points need to all of those points need to be laid out.
Yes.
So that my client has a proper opportunity to deal with each and every one of them, and then deal with the supervening allegation, which is, well, when you put them all together, you get they're only compatible with a fraudulent.
Well, that's why I want a freezing on any more evidence with your last submission.
Right.
So we're only arguing about the time, and you have shifted me on that, I think. Mr. Holloway, I'm sorry. I'm going to from what Mr. Montague-Smith has said, I'm going to give him to the 23rd of June.
Very well.
And then the rest of it, I think, just follows automatically. I don't want any suggestion that I've not given party adequate time. You've got a month after that.
Very well, Your Honour. I'm not going to. I think I can take this.
No, I think good. Okay. Okay. So I will then. So it'll be the 23rd for the first defendant's evidence, and then we go on to the 30th of June for index, 7th of July for bundled skeletons, 14th July, and hearing on the 21st. Okay. And I really can't emphasize too much that so far as evidence is concerned, the 23rd of June is the cutoff date for the evidence. One can make whatever submission one likes on the evidence, but that's it. Okay? Understood. Any other directions necessary?
None from me, Your Honour.
No, thank you.
All right. Okay. Well, thank you both. We've done pretty.
I'm sorry. I'm reminded. The securitization, there were undertakings given that nothing would happen until the return date on the 12th. That is today. So I would make 2 points on that. First, the one I made earlier, any party, including Mr. Britton or Aria or DMCC, who feel that they are adversely affected by freezing should make a proper application to clarify matters, and that's the only direction needed. But we do need those undertakings to continue beyond today.
Well, that's the first time that's been raised in front of this hearing. I obviously, sitting in London, don't have instructions to give undertakings because it's never been raised. I'm not going to be difficult about it.
Didn't ask us, but there we are.
What that I need to give undertakings.
I'm going to clarify. I will clarify what you've asked me to clarify. If it's helpful as of the moment, and we debated the securitization issue before, I work on the basis that I have found that there is a serious issue to be tried, that the sums which comprise the 6 remittances were impressed with a constructive trust. If that is right, then if those sums impressed with that trust are then knowingly received by other parties, they expose themselves to possible claims.
Claims, yes. I think we still need an answer on the meaning of your order. But listen, what I can do, and I'll pause for a moment after I can say this. I think I can hopefully give you reassurance that until you give us that clarification as to the effect of the order, whether it affects assets in the hands of fund as well, then we won't take steps until we get the clarification. Can I Can I ask my
Yes, of
solicitor
course.
just to
And I
confirm?
mean, what I'm hoping to do, obviously, is to use the time that was set aside for a 3-day hearing to produce a judgment. I mean, what I will do is certainly produce an order before the close of the 14th, if I haven't finished the writing of the judgment, but I hope to do both.
Thank you very much. That's very much appreciated, but I'm just waiting for instructions from my
Sure.
solicitors. I just want to make clear that we're not trying to sell a pass or do anything that isn't telegraphed and allows people to have a proper debate about it. Yeah, so we'll wait until we hear from Your Excellency about. I've just received instructions. We will wait until we hear from Your Excellency about the clarification that we've sought.
So when you say we will wait, you will undertake that nothing will be done until I produce my order.
DMCC will undertake that nothing will be done. I can't give an undertaking for anyone else until you produce your order. So DMCC will take no steps to. So in other words, we will continue the undertaking. DMCC will continue the undertaking that it gave beyond the date of today to the date when you give that clarification.
Just to clarify, that undertaking was given by Mr. Britton in his witness statement, and just want to clarify that Mr. Britton is giving that undertaking on a continuing basis as well.
Well, I don't act for Mr. Britton.
So the answer is no.
Well, I don't know because I haven't had an opportunity to take instructions on it.
Well, you have. You've just taken instructions.
No, let's not get into it.
I was asked to take instructions on behalf of my client, whether my client could give an undertaking. I've taken those instructions by WhatsApp, and I think we're just going to have. I'm going to have to send in I don't want to read out a series of WhatsApp messages and then be told later that I've given an undertaking that I wasn't authorized to give. So I think what we'll do, because nothing's going to change in the next 15 minutes, is I might ask my solicitors just to send into court the text of the undertaking.
I think that's sensible. What I would suggest is the present undertaking in its form be continued until I give my directions or judgment.
Thank you. All right. That well understood, and we will endeavour to get that across to you if it can be given, which I would hope it can as soon as possible today.
Okay. Good. Mr. Holloway, anything else?
No, thank you very much.
Okay. Well, thank you both for giving me a lot of work to do, and I'll get on with it as quickly as I can. Thank you.
Thank you.
Thank you. Good day.